Justice Todd, to my left, is a wonderful tradition of inviting a class from her home city, which is in far western Pennsylvania, where some of us are from, to come. And I'd like her to acknowledge the class.
Oh, thank you, Chief Justice. It's my pleasure to welcome Mr. David Gabus and his students from the Lincoln High School USAP Government and Politics class. They grace us with their presence, a new group of students every year, but Mr. Gabus brings them every year to Philadelphia on an educational trip. They take the train. They are all at my alma mater, Lincoln High School in Elwood City, and it's always a pleasure to have them. This is their 10th year coming to our court in Philadelphia, so welcome, students.
And we're all thrilled to have you and see what you think from the back of the room of how easy this job is. Welcome to everybody else. This is our last day of our fall session. It's a pleasure to be sitting live and to have all of you with us, notwithstanding the pandemic. First time in 2 years that we've been in Philadelphia, and we've missed it. I am going to do a brief introduction of the case that's twofold. It's so that people behind you understand what the case is about a little bit before we start. And it's also to make sure that we have a pretty good idea of what the case is about prior to your arguing. So if I misstate something, please correct us, because we want to be corrected. As you know, we're a hot court. We all have read everything and know everything. Don't need to know the facts. Just explain to us why you should prevail, and we'll take it under advisement when we're done with argument. We scheduled this specially. We thought it was worthy of that attention about probably a month ago. This case involves the acting Secretary of Health's school mask mandate, requiring that all school personnel and students wear masks in Pennsylvania elementary and high schools. Appellees challenged the Secretary's authority to impose the mask mandate absent formal rulemaking. The Commonwealth Court concluded that the Secretary lacked the authority to impose the mask mandate and declared the mandate void ab initio. Secretary appealed, arguing that she has the broad statutory and regulatory authority to implement efficient and practical measures for the prevention and suppression of disease, including requiring masking in schools, and that her authority to do so is independent of any rulemaking authority. She asked that we reverse the Commonwealth Court's decision. Mr. Kirkpatrick? Yeah, please remove your mask, and we're able to hear you if you don't mind doing that when you're arguing. Go right ahead.
Mr. Chief Justice, Justices, good morning. May it please the Court. My name is Sean Kirkpatrick with the Pennsylvania Office of Attorney General, here on behalf of Acting Secretary of Health Allison Beam, to respectfully ask this Court to reverse the judgment of the Commonwealth Court because the Department of Health's August 31st school masking mandate was authorized by Section 27.60 of the Department's regulations. The General Assembly created the Department of Health to protect the health of the people of the Commonwealth by determining and employing the most efficient and practical means for the prevention and suppression of disease. The General Assembly said this twice, first time in the 1905 Genesis Statute and again in the Administrative Code of 1929. To accomplish this mission, the Department has promulgated regulations under the Disease Prevention and Control Law of 1955, crafting tools to nimbly and quickly respond to unknowable future diseases. One such tool is the modified quarantine, which is defined as a selected partial limitation of freedom of movement and includes the prohibition or the restriction of those exposed to a communicable disease from engaging in particular activities. The masking order does precisely this because it prohibits individuals without face coverings from entering school buildings. Now, based upon what we know at this point about the highly contagious nature of this pandemic, especially the Delta variant, we are all exposed to a communicable disease. This court recognized in Friends of Danny DeVito that COVID-19 spreads through asymptomatic and pre-symptomatic individuals. I had to wear a mask. The individuals behind me are wearing masks today because you do not know if they have COVID, and they may not know that they have COVID. And that is the particularly pernicious nature of this pandemic.
Counselor, can I interrupt and ask you? You just said, because they don't know and I don't know. Isn't that the opposite of a known exposure, which has always been the hallmark of a quarantine? And I guess the follow-on question is there any case anywhere that's ever equated a masking order with a quarantine?
To answer your questions in order, Your Honor, so there's a difference between knowing one is infected and knowing one is exposed. So I do not know if I am infected. I'm triple vaccinated. I hope I am not. But I will not know that until I either get a positive test or I have symptoms. That's the exposure, however, is known. We are in a pandemic that is different from an endemic disease such as flu and the common cold, because it, by definition, a pandemic is pervasive throughout an entire country, or in this case, the globe. In Friends of Danny DeVito, this court recognized, in looking at where emergency was situated for purposes of the governor's emergency management code powers, that wherever two people are, there's the potential for transmission of this disease because we are all exposed to it. So in the Department of Health was created so that its experts, its, I believe, 13 epidemiologists, its physicians, can craft orders that can nimbly and quickly respond to a disaster. Now, a quarantine...
Counsel, while we're on that subject, I apologize for interrupting you, but the concern that I have is you've indicated the sections of the statutes or the regulations that you believe empower the Secretary to issue such a mandate. The question I have for you, if these existed, then why in March of 2020 did the governor exercise these same requirements and mandates pursuant to the certified emergency, 745.6? Explain that to me. Why did he not, and the Secretary not last year, do the exact same thing that you're claiming he had the power to do, or she had the power to do last year, but last year they exercised the emergency?
I believe, Your Honor, that the governor was acting under the emergency management code powers. And the Secretary, throughout that entire process, was issuing her own orders. It was the Secretary Levine at the time, that were running in parallel. So you had the governor issuing orders under his authority, under the Emergency Management Code, but you also had the Secretary issuing orders under a variety of statutes and a variety of different regulations to address specific issues. Now, the difference between a quarantine and a modified quarantine, because they are different, is the modified quarantine is a selected partial limitation of freedom of movement. So you have levels. You have isolation, which under 27.60 applies to people that we know are infected. We have quarantine and modified quarantine, which are people who are exposed. The modified quarantine is not a quarantine by just another name. It is not about taking an individual and quarantining them all.
Excuse me, where do you find the modified quarantine in the statutory section?
The modified quarantine's definition is, I believe, 27.1 of the regulation.
And I think you're still answering Justice Dockery, but part of that, how in the world is masking a modified quarantine? I mean, you're trying to shoot, and I know your purpose is laudable, I know you're trying to protect the citizenry, but as Judge Fasano Cannon said, it seems that you're trying to shoehorn the masking mandate into language that doesn't work very well for you.
I respectfully disagree, Your Honor. So we are not saying that people need to wear masks so much as people cannot enter a school building without a mask.
If there's a difference in that, it's lost on me.
Well, the difference is that in the normal quarantine situation, you quarantine an individual. With the modified quarantine, you are prohibiting or restricting a particular activity. So that could be you can go about your day, but if you want to go into a school that at the time, August of 2021, was filled with mostly unvaccinated children, you can only do it under certain restrictions. And that certain restriction is a mask mandate. And the reason that that was necessary is because in August, the department was facing two health issues. One was that, obviously, the Delta variant and the American Association of Pediatrics, I believe, speak very well to this in their amicus brief. The Delta variant was causing a lot more harm to children. A lot more children were being hospitalized. Pennsylvania is the 5th highest in the nation, and 19 children have died of COVID, I believe, since August. So you had that concern, but you also had, and this is in the acting secretary's order, beginning on page 58A of the record, you also had the concern that students are harmed both in their education and in developing social skills by not being in class. So you had these two competing goals, and the secretary could quarantine everyone, or it could just allow in-person education with no restrictions. But this was a modified version, a modified disease control mechanism that was tailored to address both issues. And frankly, that's why we have a Department of Health, is to narrowly tailor a disease control measure so that it is appropriate not only to the situation and to the disease, which is unknowable until it happens, but also to address sort of competing concerns.
So you're
Go ahead, Chief.
no, I just want to finish my comment. So your position, respectfully, and it's fine, we'll consider it, is that the masking mandate is a modified quarantine, and that's how you believe that the law authorizes it?
Yes, Your Honor.
Okay, fair enough. Justice Doherty?
I have a question. So we go back to last year, in which your position was that the governor exercised his authority to shut businesses down and require quarantine of all through his emergency powers, which he had the opportunity to exercise again, which he chose not to. The question I have for you is, you're now saying that the secretary, an unelected official, passes a mandate to issue a modified quarantine requiring children to wear masks, or they're not allowed to get their free and appropriate education in a public school. How does that regulation trump the fundamental right of a parent to decide what's best for his or her child?
Two answers to that question, Your Honor. First, it certainly does not prohibit the children from having their education through online, as they have been doing it since 2020. But
It's fair to say, you just indicated on this record that it's better for socialization to have in-school treatment. So you're not getting an appropriate education based upon your own comments, because the appropriate education would be inside. It's a modified version of education, which is permitted because the governor exercised the emergency powers, which we don't have here. So considering that the governor chose not to exercise his emergency powers, share with me how an unelected official's mandate trumps a constitutional right.
well, it certainly wouldn't, Your Honor, but there's no civil liberties claims in this case.
We could affirm for any reason, can't we? And a constitutional violation would be a basis for an affirmation, would it not?
I would caution against doing so without any briefing on the issue.
Counsel, can I ask a somewhat related but different question about the code section that we're dealing with here? It provides for surveillance, and it also goes on to say that the department can use any other appropriate control measures for the surveillance of the disease. I'm sort of paraphrasing, but you know the language that I'm referring to. Does that section allow for the daily testing of individuals entering a school building? And the reason I ask the question, I mean, the surveillance is defined. It's called the continuing scrutiny of all aspects of occurrence and spread of disease that are pertinent to effective control. Seems to fit the situation here. Here's why I'm asking the question. That's an intrusive but effective manner of surveillance. I've been fortunate enough not to have a COVID test. I too am triple vaccinated and have been very careful, but I understand it's a very intrusive test.
Yes.
That being said, if you can do that, if I'm correct in my analysis of this language, why isn't it more effective and efficient to avoid that intrusive testing and instead require masking?
Why is it not more effective to avoid that and require masking? Well, I think it is, Your Honor.
But my question about surveillance, I mean, the way I understand surveilling for COVID-19 and its various variants that are now out there is you do tests.
Yes, Your Honor. I mean, all orders, as in all statutes and all regs, must comply with the federal and Pennsylvania Constitution and people's rights thereunder. Assuming that this, and because I briefed it, I don't want to speculate, but assuming that that complies with personal liberties, then under 27.60, the third section of subsection A, yes, we could do that. But as Your Honor, I think, recognizes, to do that would require all the kids to be lined up. You bring them in, you put a swab up their nose, you have a rapid test, you isolate them until you get a negative, and then you allow them in. That is logistically doing it to young children, requiring that everyone wear masks at least until the facts on the ground change such that the concern is no longer there, that this is no longer appropriate or necessary to address this concern. That was the most efficient and practical.
But it may be appropriate, necessary, and efficient, but that's not the question. The question is whether it's authorized by law. And it seems like, following off Justice Donahue's question, it seems like a testing regime would look more like surveillance than a masking mandate. Let me put it this way. Is there any authority, any legal authority for the proposition, even going back to the pandemic of 1918 or what have you, that ever equated masking with surveillance of disease within the meaning of the statute?
So, a couple answers to that. First, the 27.60 was promulgated in 2000. But second, there's sort of two parts. Well, there's actually three parts of subsection A. The first is isolation, and we're not suggesting that this is isolation. The second is a qualified or modified quarantine for those exposed. Then we have a semicolon, and then it talks about any other means. I have that here. I'll actually
Any other disease control measure.
Any other disease control measures considered to be appropriate for the surveillance of the disease when the disease control measure is necessary to protect the public from the spread of infectious agents. So, in our briefing, we talk about essentially an alternative argument. We believe that this amounts to a modified quarantine, and again, based upon the definition, not sort of fixating on the quarantine in the name, although it is quarantining places. But the alternative argument is that this is obviously another disease control mechanism or measure. I think we all agree that masking is a direct measure to prevent water droplets from infecting other people. That third section, it talks about surveillance, but it talks about having disease control measures with that surveillance. So it really is, surveillance is passive. It doesn't control disease. It only teaches you about it. So in order to have that work, there needs to be a disease control measure. There's the study, a disease control measure is implemented, there's more study, and you refine it. Those two have to go hand in hand, or else you don't have control. You merely have study.
Mr.
Counsel,
Kirkpatrick?
Can I interrupt you there for a moment? Because I'm going to go back to the definition of surveillance. And I'm trying to help you here, okay? I mean, I'm just, in the sense that I've spent a lot of time reading every definition in the statute and your code, and I'm trying to understand what's happening here and why you believe it has to happen. So, surveillance of disease is defined as the continued scrutiny of all aspects of occurrence and spread of the disease that are pertinent to effective control. So it is not surveillance just to know what's going on. It's surveillance pertinent to effective control.
Exactly.
And so, in looking at this, I think it's abundantly clear that the other control measures that are referred to in 27.6 are tied to surveillance, which is intended to promote effective control.
Yes, Your Honor.
And so I'm asking you if masking in this context is your alternative measure to the effective control that's anticipated by the surveillance that's permitted by the code section.
Yes, Your Honor.
Okay.
We make both arguments, and you make my argument better than I do. So,
Mr. Kirkpatrick,
Justice Todd has a question.
Mr. Kirkpatrick, I'd like to go back to Justice Dougherty's earlier question and your comment, of course, that this issue wasn't briefed. But Justice Dougherty asked, don't parents have the right to decide what's best for their children in terms of masking or not masking? And my question is, doesn't this measure actually address what's best for other children so that parents aren't just deciding, is it my wish for my child to be masked or not? Do I think it's best for my child to be masked or not? But rather the whole group, the whole society, the whole membership of schools, what's best for all of them to have the children masked so they're not spreading the disease potentially to one another. It just seemed to me that the emphasis of your argument was more on the global protection and not so much on what individual children are required to do. Am I reading it wrong?
no, you're reading it correctly, Your Honor. It's the sort of famous statement that a person's freedom ends at your neighbor's nose. We cannot, we live in a society, and society has rules, and society has personal liberties, but it is not, we are not our own, everyone is their own king in all regards, especially when you're out in society. So all orders must comply with the protections granted to us under the Constitution. But the courts have, especially the U.S. Supreme Court, in dealing with a lot of the COVID matters before it in a variety of different areas, constantly sort of come back to the idea of masking, even when it finds other means to be prohibited. Sort of there's this understanding that whether it be Philadelphia, whether it be this court, whether it be the CDC and public transportation, whether it be in airports, that masking not only protects you, it protects everyone else. And the way to protect the students who at the time were mostly unvaccinated, I don't know what the numbers are today, but it takes time to vaccinate millions of children. The way to protect them while allowing a in-person education was to establish an appropriate restriction. That appropriate restriction was everyone must wear masks.
Well, isn't it also true that no child, no parent is compelled to wear the mask? No child is compelled to wear the mask. No parent is required absolutely to mask the child, because there is an alternative offered, and that is remote learning until it's safe to return to school without a mask.
A couple things. Yes. Also, there's no requirement that a parent or visitor or child wear a mask outside of a school building, on a playground, for example. There is also 8 exceptions to this mask mandate that are in the masking order that talks about disabilities and the like. So the reason, and I sort of come back to again, what is the mischief being sought to be remedied? What is the original intent? The original intent, not only of this reg, but of the 3 authorizing statutes, is the General Assembly cannot look in the future and say, we're going to get hit by a pandemic, it's going to have these features, these disease control measures are going to be effective, these are not. We're going to legislate for that. Instead, what they did was they created a Department of Health staffed with experts, gave them the power to promulgate regulations. The department did so.
But that's the problem, isn't it? Because there's no question about the intent or about the appropriateness, at least for the sake of argument, let's concede all that for the sake of argument. The question is here, if you had all this broad authority that you're talking about, why is resort to all these specific laws and regs even necessary? Because the argument, or one of the arguments coming from the other side, is that if you wanted this masking power, you needed to go through the rulemaking process. I don't mean you, I mean this acting secretary, and failed to do that. And in the absence of rulemaking, in the absence of express statutory authority, the acting secretary doesn't have power to sort of just do whatever she wants for the good of the order, so to speak. We don't have that sort of gap-filling authority. Can you react to that?
Yes, Your Honor. We agree that there needs to be a reg in order to provide a mandate. 27.60 allows that. Now, if I can speak to my friend's discussion about the rulemaking process, the rulemaking process worked here. It happened in 2000 when we promulgated these rules. There is no use of the word mask in 27.60, but that isn't dispositive because you need to read the regulation with the, and we discussed this in our opening brief, an understanding of not only its purpose, but the authorizing statutes, and look at the text and see if this particular mandate falls within that text. And again, this is a prevention or restriction of an activity. Entering a school building without wearing masks in order to protect children from a deadly communicable disease.
I think that's a fair answer to Justice Wecht, and Justice Dougherty has a question.
I'm trying to understand your argument. I read it as well as Justice Donahue. I see that the Secretary discussed the plethora of codes or statutes or regulations that she relies upon. But if I follow your argument, under the control measure, the 521.5 specifically says, as provided by rule or regulation. It appears that the emphasis of your argument is that the mask is defined by the modified quarantine. Am I correct so far?
Yes, Your Honor.
Now, under the modified quarantine is to, quote unquote, partial limitation of freedom of movement. Share with me how wearing a mask falls within the definition of partial limitation of freedom of movement, taking into consideration that we have a definition for isolation and we have a definition for quarantine, and both are requiring the restriction of absolute movement, meaning you're not allowed out of your house, you're not allowed here, we're shutting this down. How is wearing a mask a partial limitation of the freedom of movement?
So the
And I apologize. And how do you base your decision upon that? Is that a policy decision that the Secretary makes? Is this an interpretive position of the Department of Health? I'm somewhat confused.
Okay. So selected partial limitation of freedom of movement. And that term includes exclusion of children from school. So right there, we have a situation where we're not locking children down. We're excluding them from school.
You're limiting their freedom of
They're
movement.
limiting their freedom of movement and the prohibition or the restriction of those exposed to a communicable disease from engaging in particular activities. We are not saying that anyone has to wear a mask. What we're saying is you cannot go into a school building unless you're wearing a mask.
And why, let's use Judge Donahue's example. Wearing a mask would require a child to be masked for 8 hours. If we're going back to the definition of surveillance, and we understand surveillance is so that we can have control of this disease, why not invest and expend time on with the testing? It would take 15 minutes, maybe a half an hour, which is substantially less time than the 8 hours of a child wearing a mask. And I question, to follow up that question, is it your position that testing a child in school is not a partial limitation of their freedom of movement?
No, I'm not making that argument. If you're excluding them from coming to school unless they do so, no, that would be. So now we get into not so much whether this order falls within the text of 27.60 and whether it is wise or whether there is a better way to do that. And I would submit that that is a policy decision that is best left to the public health officials and the experts to...
But policies decided by the General Assembly, correct?
The overarching goals and policies, absolutely. And what the General Assembly did in this case was create a Department of Health.
But I apologize, but the circular argument is that the Secretary can make regulations as a delegation of its legal authority from the General Assembly, provided it follow the procedure discussed by the General Assembly, which is the rule and regulation process.
Yes.
Through the Commonwealth document or the regulation review, and or exercise of its emergency. Which brings us back to the scenario is, why did the Secretary not, or the Governor not publish for a regulation or exercise pursuant to the emergency application?
Because the authority exists in 27.60.
And again, 27.60 is control measure, correct?
Right.
Disease control measure.
And it says there, as provided by rule regulation. So that really, in my mind, doesn't give the Secretary the authority. It does, provided you follow the rules or regulations, which are defined by the Commonwealth document or the Regulation Review Act. So
Let me clarify my
I
argument.
think we've been over this multiple times, but why don't you answer very succinctly one more time for Justice Dougherty?
because I haven't gotten an answer that I understand.
Well, I apologize, Your Honor.
You haven't
so
found
the
one
dis-
that's going to convince you.
The disease control law allows the department to do disease control measures pursuant to rule and regulation. There is a regulation in place, 27.60. If this court finds that this school masking order falls outside of that, then we lose. But we did not need to promulgate a new regulation to issue an order, just like the Department of Labor doesn't have to promulgate a regulation to shut down an elevator, or the Department of Agriculture to quarantine a flock of chickens. It either has that authority or it doesn't.
Fair enough.
And we argue, respectfully, believe that the language, when viewed in the context of in para materia, we have that authority.
May I ask you very quickly, when I read your brief, which came in very late because we expedited everything, I thought you were going to rely on 2102A of the Administrative Code and Section 8 of the Department of Health Act, but you've argued this exclusively from 2760. That's fine. That may well be your best argument. But when we write it, what you just said to Justice Dougherty is that you stand on 2760 and you prevail or you don't prevail on that, and that's what we need to opine to.
We discuss the Department of Health Act, the Administrative Code of 1929, because you cannot read, and this is one of the, I believe, errors of the Commonwealth Court, words in isolation. You have to read the statutes and the regulations pursuant to those statutes together.
All right, but 2760 is the ballgame
That's
for
the
you.
source.
Counsel,
They could win Pyrrhic victory. Is there anything at all, if you don't preclude here, that stops a school district from a mask mandate or a building principal from a mask mandate? I'll ask them that.
I don't believe so, Your Honor.
Okay, thank you.
Counsel?
One last
Counsel,
question.
Counsel, before
I'm
you
sorry.
sit down, are you sharing your time, or maybe I'm asking the wrong person this question? Okay. The Commonwealth Court, and I believe your opposing parties, have suggested that the emergency procedures that are available under the Pennsylvania Regulatory Review Act were available to you. Now, I know you're of the view that you didn't have to promulgate any additional rules and regulations, but let me just ask you your view of the idea that the emergency procedures were available, with specific reference to one section of that emergency section that provides that this emergency procedure can come into play with the immediate effectiveness of the regulation. If the governor certifies that the final form or final emitted regulation is required to meet an emergency, which includes conditions may threaten the public health, safety, or welfare, does that anticipate the governor formally declaring an emergency in order for this section to come into play?
I don't believe so, Your Honor, but that raises, obviously, the governor has to agree that this warrants emergency certification, but also the idea that this can instantaneously happen, as we discussed in our opening brief, is a fallacy. It can't. There is a lot of process in the front end, and the example used by the one example from, I believe, the 1980s that the Commonwealth Court references dealing with insurance had months of prep work to even get to that point.
When that was promulgated, did we have a divided government in Pennsylvania? I just don't know historically. I mean, was the legislature controlled by one party, and the as we now sit with Republicans in the legislature, a Democrat in the executive branch?
I have no idea, Your Honor.
It would make a difference, would it not?
It would, from a political standpoint.
Let me ask you why you don't think that this section of the Regulatory Review Act that I just read to you doesn't require a declaration of emergency. Are you relying on the inherent police power of a governor to say that there is an emergency?
I believe, yes, Your Honor, I believe that emergency can exist without necessarily declaring an emergency, which is a specific act that triggers a variety of different powers. That being said, I did not brief that issue, and so that is my understanding, but I could be wrong on that.
Okay, thank you.
Thank you very much.
Can I ask one question?
Sure.
Just it's a follow-up on Justice Donahue's question. And we received an amicus from the chair of the PA House Health Committee. And in the brief, what I gleaned from it, in any event, was that to obtain this emergency certified regulation process is basically a two-step process. The governor certifies this regulation is necessary to respond to an emergency, and it's published in the Pennsylvania Bulletin.
That, as we explained in our opening brief, Your Honor, that discusses the very end of the process, not the entirety of the process. And even still, the time to take to publish, days delay can cost lives. So
Well, if that's your argument, though, why would you file a regular appeal to our court as opposed to a King's Bench when this initially was resolved by the Commonwealth Court? Why wouldn't you just say, boy, if the Commonwealth Court thought we did this wrong, what's the quickest way for us to get this resolved, because the health of our citizens are at issue? Why wouldn't you immediately go back to your desk and start banging out a procedure that the Commonwealth Court said would be applicable.
Because we immediately appealed, and we have an automatic supersedence, Your Honor.
Which you almost lost. Thank you very much. We understand your argument. Well, Mr. Breath, please, for what it's worth, it seems to me that your friend on the other side has narrowed the argument. There's one paragraph of 27.60A, and he was very candid that he rises or falls on that paragraph. So if you can hone in, I think we can do this a little quicker.
Please, the court. Good morning, Mr. Chief Justice Behr, justices. As Chief Justice Behr has indicated, I'm Thomas Breath. I'm here with my colleague, Mr. King. We represent the appellees in this case. I was happy to hear that we've narrowed the issue down. Let me explain to you why their interpretation of their own regulation doesn't warrant deference from this court. First of all, there's a clear acknowledgement that Section 521.5 of the Disease Control and Prevention Act is not ambiguous. It's clear. There has to be an existing regulation. They have argued now, and if you read the order, and I'd reference it to you, this is a different argument than what's in the order. The order is very, very, very clear. I can't emphasize that enough. The Secretary of Health, the Acting Secretary of Health, indicated that they have the authority, any disease control measure. Isolation, if you look at code, and I'll walk you through it, the regulation sections, that is not another disease control measure. And I'll reference you to the regulation sections that have been referenced, 2760. It walks through, and it's basically three parts. The department shall have the authority to direct isolation of a person, et cetera, not at issue here. We don't have isolation. 2, surveillance, segregation, quarantine, or modified quarantine of contacts of a person or animal with a communicable disease or infection. They've now started to rely upon that. And third, the third element, and any other disease control measure the department considers to be appropriate for the surveillance of the disease, et cetera, et cetera. It's that third part that the Acting Secretary of Health relied upon in the order. Nowhere in the order does it talk about modified quarantine. Never mentioned. Wasn't mentioned in the briefing before the Commonwealth Court. It was slightly, they dipped their toe, if you would, in oral argument into the modified. It's an acknowledgement that they're failing to meet, this is not a surveillance mechanism. So they had to move to a modified quarantine. It's important you read the definition, with all due respect, I know you do. You read the definition of what a modified quarantine is. And their arguments are, they're interpreting their own regulation in two distinctly different and contrary manners. So when you read the definition of modified quarantine, is a selected partial limitation of freedom of movement. I'll leave it to your discretion to determine whether you believe that wearing a mask is limiting somebody's freedom of movement.
Well, that's not his argument, Mr. Breath. It's that freedom of movement into a school is restricted, that children cannot, or adults cannot be inside a school building, move into a school building unless they're wearing a mask. So I think their argument is the flip side.
Only if the mask were tied around their ankles, then that would restrict their freedom of movement, right?
I appreciate that, Justice Weck. I'll refrain from commenting on that, but determined on the basis of differences in a susceptibility and dangers to disease transmission, which is designed to meet a particular situation. Modified quarantine includes, but is not limited to, the exclusion of children from school and the prohibition or the restriction of those exposed to the communicable disease from engaging in particular activities. If we have students that are of compulsory attendance age in the Commonwealth of Pennsylvania, these students not only have the obligation and their parents have the obligation, they have the right to go to school. Nowhere in the order does it talk about, and I could be corrected, I skimmed it real quickly, that schools are compelled to provide virtual instruction to these students. It's not mentioned in the order.
But as a practical matter, all schools in the Commonwealth are offering that as an alternative, aren't they?
That is something that I don't know. I don't know. I don't know if all schools have that. I don't know the quality of that education. I don't know if it addresses all the special needs of the students. I don't know if it creates difficulties for parents that work during the day that don't have the ability to be home with their special needs students, or have multiple special needs students at home where they're trying to educate one online while dealing with the other ones. There's a whole litany of issues that are involved in that quite honestly are outside the scope of what's before this court. We're here solely on the issue of, does the order as it is written in its four corners provide for the statutory or regulatory authority to implement that?
Let me ask you this, Mr. Breth. If the Secretary, instead of imposing this mask mandate, had imposed a mandatory COVID testing protocol on the students, that every day when a child arrives at school, the child has to submit himself or herself to testing, which can be somewhat invasive, would that be acceptable under the regulation in your mind as opposed to mandatory masking?
No, it would not be.
I had a feeling you'd be here either way.
I have a question.
Although you'd have a much harder.
Could you answer
Why?
that?
Why? Could you answer why you don't believe it covers it?
Well, I don't believe there's a regulation that provides the authority to that. The surveillance is not testing. It's a misnomer to believe that the definition of surveillance somehow is a masking and or a testing.
Well, what is surveillance then in this scenario?
Oh, it's not this case either.
Well,
We may see you in the spring on that issue.
It's defined, and that's the next definition. And just for clarity's sake, this is section 521.2 of the Disease Control and Prevention Act that defines this. Surveillance is the close supervision of persons and animals exposed to a communicable disease without restricting their movement. And this is the inconsistency in their interpretation of their own regulation. One moment they're saying we're restricting their movement. And the next moment we're saying, but no, we're not restricting it because we want it to be surveillance. And I'll walk you through the statute because surveillance, it actually talks about paragraph B. We've been talking about paragraph A, the regulation. Paragraph B really talks about what is surveillance and how do you determine the appropriateness. So I'd reference you, if I would, to 2760 disease control measures. I talked about the three different elements of paragraph A. Paragraph B, the department shall determine the appropriate disease control measure based upon the disease or infection, the patient's circumstances, and the regulation uses the term patients, the type of facility available, and other available information related to the patient or the disease or infection. So when you get to that third layer that the order relies upon, the acting secretary's order, and it talks about this is an other disease control measure, paragraph B talks about how you approach that. And I would reference the court back, and I'm not going to walk through all of them. When it talks about determining the disease, you need to go further back into the regulations where it talks about the various diseases. When it talks about the patient, there's regulations. 27, section 152 talks about an investigation, the ability to access the patient's medical records as part of that investigation. The type of facilities that are available. What type of facility are you putting this person in? Evaluating what's appropriate. And then any other available information. Are they students? Are they healthcare workers? Are they daycare center workers? Are they food handlers? All of that's spelled out in the existing regulations.
May I stop you, because we're not arguing the case before us. We're arguing the case that may be before us in the future, which is whether or not the secretary has the right to test as people enter the building. So let's get back to the case before us now, which is the secretary chose to do the mask mandate. You say the secretary can't do the mask mandate. I don't know, Justice Docker, do you still have a question?
Yeah, I just had one question. Assuming this court accepts your argument, the Secretary of Education has provided with each local educational agency the ability to develop its health and safety plan, which encourages the use of masking. So in essence, despite the fact that you could possibly win here, masking would be based upon the local educational agencies, correct? each individual school districts?
Well, that would be a combination of the Pennsylvania Public School Code, the State Department of Education regulations would need to be read to determine whether the local boards of school directors.
And you would likely object to that as well.
And I understand you're talking about my clients, not me personally.
Yes.
Would there be clients that might call and say, is that something that is provided for? We would certainly do that analysis as we've done the analysis here.
Sure, that's a fair
I
answer.
just want to reemphasize.
Well, in any event, that's totally irrelevant. I mean, the question is
not
whether
before
the law gives the acting secretary the authority for this, rather than some irrelevant thing that may or may not occur in the future, right?
I agree completely. This has become such a divisive issue in society. We all acknowledge that.
And you're a lawyer arguing your case.
I'm arguing my case.
It's not personal, we understand that. It's
Absolutely.
not personal
But
for
it's
us
personal-
either, we're going to decide the case.
It's personal to us all that we protect our children, that we have schools that operate and function efficiently, that there is not discourse. The problem we have is when you go outside the regulatory process and you have one person that issues an order, and the acting secretary, and I'm not-
that's
I'm not
really, that's really the only issue here. We have these overarching views, societal views. Should you mask? Should you not mask? Should you be told to wear a mask? Can you not be told to wear a mask? Where can you go without a mask? You're all sitting here with masks. Right now, we have these overarching concerns and differences of opinion, but Justice Wecht has pointed out, and it's just absolutely correct, that no matter our views on any of that, what this comes down to is, can this particular order by the Secretary be justified under this regulation or under the statutory authority? And that's really what it comes down to, a very, very small analysis on what is admittedly a very big issue.
Trying to keep ourselves,
Yes.
as eloquently said, narrow. Is there anything else you'd like to add?
Well, I think I'd just add, with respect to the emergency powers that are provided for under the Regulatory Review Act, I think it is important to note that it is that very narrow issue, but it doesn't mean that if you rule, as we are asking you to rule and sustain the Commonwealth Court decision, that the acting Secretary of Health doesn't have, as I refer to it, tools in the toolbox. It isn't overnight. But we've been dealing with the issue of masking in schools for months and months and months. This case has been being litigated for 3 months. So it's not as if the governor and the acting secretary of health haven't had adequate time to take advantage of that. And the fact that they're saying, well, it just isn't going to happen overnight, their failure to move it forward isn't an excuse for requiring them to utilize it. They've chosen not to.
Again, respectfully, Mr. Breath,
Thank you, Your Honor.
I was just going to say, none of that really matters. I understand this is a intensely personal issue in a divided country, but we just have a legal issue as to whether or not this action is countenanced by this paragraph of 2760, and we'll decide it.
Mr. Chief Justice, thank you. Thank you,
Thank you
Justice.
very much. Environmental Defense Foundation filed a declaratory judgment action against the Commonwealth and Governor Wolf, challenging the provisions of the 2017 and 2018 General Appropriations Act and legislative amendments to the Fiscal Code as violative of the Environmental Rights Amendment to the Pennsylvania Constitution. The Commonwealth Court denied in relevant part the declaratory relief sought by the Pennsylvania Environmental Defense Foundation, which filed a direct appeal with this court. We granted oral argument to consider a subset of the issues raised by the PEDF, specifically whether the appropriations from the Oil and Gas Lease Fund for general operations of the Department of Conservation and Natural Resources violate the ERA, and whether monies in the lease fund which derive from oil and gas leasing in north central Pennsylvania may be constitutionally expended outside of that region. So those are the two issues, and feel free to proceed, Mr. Child.
Thank you, Your Honor. May it please the court, my name is John Child. I represent the Pennsylvania Environmental Defense Foundation. 50 years ago, the people of Pennsylvania enacted Article 1, Section 27 to Pennsylvania's Constitution.
Counsel?
Will you put your mic a little
Microphone
closer
down.
to your face?
This one, or?
It's pretty directional. Thank you.
Okay. Would you like me to begin again?
No, you can pick up where you were.
Thank you. Establishing the people's inalienable rights to protection of Pennsylvania's public natural resources. In that amendment, the people specifically mandated a new role for the Commonwealth to be the trustee of the trust created by the amendment with the fiduciary duty to conserve and maintain the corpus of the trust, the public natural resources, and to protect the people's constitutional rights thereunder. This case is about saving the crown jewel of Pennsylvania's public natural resources, Pennsylvania's state forests, and specifically the 1.6 million acre core of that state forest in the north central part of Pennsylvania, known as the Pennsylvania Wilds. The record establishes that about 13 years ago, in 2008, the Commonwealth discovered the wealth of the oil and natural gas located in the shale deposits under the forest. In 2009-2010, the Commonwealth mandated that DCNR lease over 100,000 acres of state forest to extract the oil and gas for revenue. Adding that 100,000 acres to the existing acreage under lease, our state forest now has 600,000 acres subject to the Marcellus shale gas extraction process to obtain revenue. The record in this case also clearly establishes that extracting oil and natural gas from the state forest has already caused immediate and long-lasting degradation.
Mr. Childs, I wanted to give you the chance. It's our protocol to give people a couple minutes to get going, but
Yeah.
so far, with great respect, you're not touching on the issues before us. It's just quite pure questions of law, as the last case was pure questions of law. Can the oil, gas, and lease fund monies be used to run the overhead of the Department of Natural Resources? And can you spend the money from the oil or the gas extracted from Region A and Region B? Those are your two issues. Can you direct yourself to them? Either one.
Your Honor, but with due respect, I would argue that the statements I've made regarding the protection of the natural resources of the state forest are critical to understanding those issues.
Well, as you know, we've opined before, and you prevailed on the importance of the Environmental Rights Amendment. So you start with that taken, given stare decisis and our recent opinions. You have two subset questions, whether you push too far in these cases.
Your
Counsel,
Honor.
if I could ask a question that may help assist narrowing the issue.
Thank you.
The environmental amendment specifically says, Section 27 specifically uses the word trustee of the resources. It does not prioritize the use of or the allocation of its funding. Why should we do anything other than what the amendment reads? Why does it have to be specifically applied to the area where the gas and oil is drained as opposed to funding the Department of Conservation?
Because, Your Honor, we're arguing that the revenue comes from the extraction of the oil and gas on Pennsylvania state forest. It's a result of that extraction, the state forest has been degraded. Once that public natural resource has been degraded, the revenue that was obtained from that extraction must remain part of the state forest.
With all due respect, sir, share with me
Yes.
in Section 27 where that is specifically indicated that the resource from which it's drained the money should be used there. It says trustee of the resources to make sure our great state remains a great state with our air, water, and environment.
Because, Your Honor, the very purpose of the trust is to conserve and maintain the public natural resources. That's the heart of the amendment. And it's the mandate upon the Commonwealth to specifically protect those public natural resources by conserving and maintaining them. And as
You're not answering Justice Dougherty's question, and I don't know that there is an answer to it. If we take oil and gas out of Tioga County, and there's a creek that's a toxic waste dump and needs to be cleaned up in Bucks County, you're suggesting we can't use the monies from the Tioga County oil and gas to clean up the Bucks County Creek. And what Justice Dougherty is saying, that the ERA talks about Pennsylvania and not about Tioga and Bucks County. That's as specific, I think, as we can
No,
get it.
that's exactly. It says common property of all people, not the people from the area from which it's drained. But I would like you to answer the Chief's question. That's exactly.
You follow my hypo?
Your Honor, the purpose of the amendment is to conserve and maintain the public natural resources. You can't take away from one of those natural resources to benefit another. Now, you're
Why
familiar...
not? That maintains the natural resources.
Why not? Isn't that
Because it...
by the trustee? Isn't it up to the trustee to exercise its judgment in the expenditure of the funds?
Not at the detriment of one of the principal public natural resources of the Commonwealth.
One of the principal natural resources of the Commonwealth is water. What about the acid mine drainage that still pollutes the streams and rivers in this Commonwealth? Are they to ignore those?
But Your Honor, you cannot degrade the state forest to preserve the water.
Mr. Child, would you? I'm sorry. Finish your answer. I don't want to beat you up. This is just what we do. Do you have any citation of any law, any regulation, any case that's supportive of the idea that you can't use the monies from Tioga County in Bucks County or in Butler County?
Your Honor, I think your decisions in PDF 2 and PDF 4 directly support that argument.
All right, that's a fair answer. And we
Wouldn't
can certainly reread them.
the issues that you're raising, counsel, go to management, if not micromanagement, of what the trustee's job is to do? That is to say, if the conservation of the public natural resources is being done with fidelity, it's not for the court to say it must be for this particular natural resource, this park, as opposed to that forest, as opposed to this natural resource. Is it the role of the court to tell the Commonwealth, to tell the political branches how to micromanage aspects of the trust?
I don't believe so, Your Honor. It is up to the court, however, to decide if the Commonwealth has it violated its duties as trustee in that management. If the Commonwealth has made a decision to take part of the public natural resources, which are our state forests, and applied it to, say, Point State Park in Allegheny County, that benefits Allegheny County, but it degrades the natural resource in the north central part of the state. Our natural resources aren't one entity. There are a great deal of resources, and Pennsylvania is blessed with them, but you can't degrade or destroy one resource to benefit another. That makes it management by politics rather than management by ecosystem of the state forest.
I think we understand that argument. You want to comment on the second argument, which is the idea that the oil and gas lease monies cannot be used to pay the overhead of the Department of Natural Resources, Conservation of Natural Resources.
Yes, Your Honor. As you pointed out,
Just to direct you there, you know, I think one of the briefs said that conservation is not done in a vacuum. You need people, you need equipment, you need an administration, and we haven't heard they're acting ultra vires. So why is it not appropriate for this trustee to use the assets of the trust in furtherance of the trustee's goals?
because, Your Honor, this court has found in PEDF 2 and PEDF 4 that the general operations of any agency, including the Department of Conservation and Natural Resources, is a non-trust fund purpose. To be able to pay salaries, to do contracts, has nothing to do with the conservation of the natural resources.
Counsel, if I just might interject, I'm very familiar with our holdings in those cases, and we never said that vis-a-vis the Department of Natural Resources or Conservation. I mean, what we've said is that when possible and in general, the principles of trust law apply. And the principles of trust law, as articulated in the Restatement Third, allow the trustee to use money from the trust for the administration of the trust in its discretion. Who else is going to pay for the administration of this trust that's created in our Constitution?
Your Honor, they should be paid for through the proper Article 3 rights that the Commonwealth has to fund these requirements. They should not be paid for through the destruction of our state forest to get the money in order to pay for it.
So you don't believe that the Restatement of Trust Second and Third, Section 198, apply to the administration of this trust? Somehow that aspect of trust law doesn't apply to the trust that's created by our Constitution?
Your Honor, if that restatement authorizes the degradation of part of our natural resources in order to pay for other natural resources, then yes, I would say it does not apply.
All right. Thank you. Is there anything you'd like to add in summation?
We rely on our brief, Your Honor.
Thank you so much. Mr. Ebersol? As you can tell, we understand the issue and
We've written a little bit on this topic.
right. My advice would be to be succinct, but it's your argument.
Well, good morning, Your Honors. My name is Joshua Ebersol, and may it please the Court. I'm arguing on behalf of the Commonwealth of Pennsylvania and Governor Wolf. The two issues before the Court are whether the Commonwealth and the Governor have violated Article 1, Section 27, in funding the general operations of the DCNR, and whether or not the oil and gas lease fund money should in any way be restricted by region or public natural resource. The funding of the general operations of the Department of Conservation and Natural Resources is constitutional And as this court had found in the prior decisions in PEDF 2 and recently reiterated in PEDF 4, the funding of an agency that is dedicated to effectuating Section 27 does not run afoul of the Constitution. And that is consistent with trust law, which provides that the expenses of administering a trust are to be paid out of that trust, and that a trustee is able to incur necessary or appropriate expenses in its administration and is to be indemnified out of the trust for those expenses. I believe the parties agree that the DCNR is a trustee over a portion of the public natural resources, specifically the 2.2 million acres of state forest land over 200 state parks. As noted in the Commonwealth's brief, this requires a large staff of employees, many of them experts in their field, counsel, vehicles, equipment, in order to conserve and maintain the public natural resources for the benefit of the people and generations yet to come. Your Honors, what the foundation is requesting is essentially to say that the trustee, Commonwealth, and governor appropriating monies to a co-trustee of the DCNR is unconstitutional. And that simply is not consistent with trust law or this court's prior decisions. This is a matter of following the money through an accounting, as the Commonwealth Court correctly granted below, and as this court had noted in PEDF 2, to ensure that the money is spent consistent with Section 27. And on the second issue, the monies are in no way restricted to any one public natural resource. They are, or region of the Commonwealth. The monies in the oil and gas lease fund, while yes, they are derived from the state forest, trust law would provide that the trust itself is made whole through the rents, royalties, and bonuses received under those leases. And the Commonwealth Court, in regards to this argument by the foundation, called it myopic, and the Commonwealth and the governor agree, noting the numerous threats faced to the Commonwealth from climate change, invasive species, and water quality, in which these monies may be used, and that the Commonwealth needs to have discretion as a trustee and pursuant to trust law to use the monies in such a manner to address the conservation and management of our public natural resources.
Well, the trust cannot be administered without administrative costs, correct?
Correct, Your Honor.
And somebody has to decide in his or her discretion, in its discretion, how those expenses are to be paid, and here it's the Commonwealth as trustee, correct?
Correct, Your Honor.
Does that mean, counsel, that the constitutional provision would not be violated if the Commonwealth chose to pay the entire DCNR budget with these funds?
As long as the money is spent consistent with Section 27 purposes, it would not. So as long as all of the expenses of the DCNR were consistent with Section 27.
Well, that's my question. Is it per se? I just want to probe how far the argument goes. Is it your view that per se, everything by definition that DCNR does is flowing from this constitutional mission, this trust, such that supposing the Commonwealth said we're going to use this fund for the entire budget of the department, in your view, that would not be constitutionally problematic?
Well,
do you follow me, or
yes,
should
I do, Your Honor. I guess to note first, that's not the case before us here. And as the Commonwealth had noted in their brief, taking judicial notice of the substantial other appropriations the DCNR receives in addition to the oil and gas lease fund monies. Your Honor, the DCNR is certainly a trustee over portion of the public natural resources and carries out numerous other conservation initiatives throughout the Commonwealth. It was created in part to effectuate Section 27. However, there certainly could be costs that the agency would have that perhaps would be unrelated to administering the trust and would not be able to be paid out of the trust.
So it's not your view that the mission of DCNR inherently is to conserve and maintain our natural resources such that what they do is this conservation of this trust, that they could pay their payroll, they could pay their office overhead, they could pay everything. I'm just wondering whether that becomes an exercise in creative accounting.
Your Honor, certainly the mission of the DCNR is to carry out conservation and maintenance of the trust. And the Commonwealth argued in its initial briefing that any expenses of the DCNR would be consistent with Section 27 trust purposes.
Until they're not, and we can rest assured somebody will bring the case. So
Correct.
we'll worry about that when the time comes.
Correct, Your Honor.
Anything further from anyone? Thank you so much.
Thank you.
Rendered the defendant unconscious and unable to consent to any testing for drug use, hospital personnel drew his blood, and a subsequent test of that blood indicated the presence of marijuana. Without obtaining a warrant, the Commonwealth procured the results of that test. The trial court suppressed the blood test results, and the Superior Court affirmed based upon recent case law from the United States Supreme Court and this court. The Superior Court concluded that neither Section 1547A or 3755A independently supported implied consent on the part of the driver suspected or arrested for the DUI violation. In addition, the court concluded the facts underlying this matter did not present exigent circumstances. We granted allowance of appeal in this active area to consider whether the Commonwealth's contention that the Superior Court's decision does not comport with the United States Supreme Court's jurisprudence and our jurisprudence was accurate. And if that's a reasonable summation of where you are, Mrs. Lombardo, tell us why the lower courts got it wrong.
Thank you, Your Honor. Good morning, Chief Justice. Justice of the Pennsylvania Supreme Court. I need to make one very minor procedural correction, as it does impact standard of review and sort of how we got here. Following the original suppression motion prior to Birchfield and all these subsequent United States Supreme Court cases, the trial court originally denied suppression, finding that exigent circumstances were present. And then on post-sentence motions, time expired prior to the trial court rendering an opinion on the on the post-sentence motion, and then within his 1925A opinion, then reversed himself as to whether there was exigent circumstances.
Yeah, and as I said, it's a very developing area of the law, and I appreciate the nuanced correction. Thank you.
Thank you, Your Honors. Your Honors, I'm going to start with the Mitchell argument, as I know this Court's preference is to deal with non-constitutional arguments over their constitutional brethren. Simply put, during our oral argument before Superior Court, Mitchell versus Wisconsin was being argued before the United States Supreme Court. And we all acknowledged before that panel that this case would have a significant impact and a controlling impact on the resolution of our case. In Mitchell, facts are substantially similar. A defendant drank himself to the point of unconsciousness, and despite efforts, the police could not ask for an implied consent test, as he was unresponsive. As a result of him losing consciousness, police requested a blood draw. Such blood draw was completed, and our Supreme Court, our United States Supreme Court, ultimately held that where a driver is unconscious and there's probable cause to believe there's a violation of a driving under the influence statute, almost always will a warrantless draw be appropriate. And what I think is curious about the United States Supreme Court decision is it looked at really what is the totality of exigency, going back not just to McNeely as the Superior Court did, but going back to Schmerber, which was our really first case looking at exigency in the DUI context. And I think of McNeely as being the center of a exigency Oreo that's bracketed by Schmerber and now Mitchell. If we look at Schmerber, that was a case where there was an accident. And that accident and the divided attentions of the police officers in handling both the accident and their other pressing duties, and the metabolization and dissipation of alcohol within the blood created the exigency necessary. Yes.
Counsel, that's exactly my point. The cases you cite and the arguments and the developed opinions were based upon the dissipation of alcohol. That's not what we have here. We have a controlled substance, marijuana. We also know that the legislators created a statute which we define as the 2-hour rule. Yet the 2-hour rule is for alcohol only. And as a result of that 2-hour rule, that is the thing that implicates and creates the exigency. We know, as a rule of thumb, marijuana staying in your blood for 30 days, at least. That being said, share with us why we should follow your argument when we're using a completely different substance for purposes of exigency.
Your Honor, I thank you for asking that question. So this implicates two cases. One is Your Honor's most recent case, Commonwealth versus Trahey, which looked at that 2-hour rule and the idea of the per se DUIs with substances. But there's also our sister jurisdictions who have addressed the issue of controlled substances and what they described as the unknown substance. So I'm going to start with Trahey, as that's our Pennsylvania case. In looking at the per se's of 3802, Your Honor is absolutely correct. Any amount will be sufficient to establish that violation. This is not a case merely of, and I say merely, not to in any way diminish the importance and the impact of DUIs, but this was a vehicular homicide while DUI, as well as an aggravated assault by DUI, where we're not just looking at the mere presence of a controlled impairing substance. Part of the critical analysis of vehicular homicide while DUI and aggravated assault by DUI is criminal negligence, and that the accident was caused by impairment resulting from those substances.
But we have the additional fact that the individual emanated like marijuana. Does that not change the scenario? We know it's marijuana. He's told it's marijuana. The police are told it's marijuana. He's unconscious. Why not get a warrant?
Because in this, Your Honor, and I'm going to loop back to that other sister jurisdiction case, I apologize. I want to answer your question first. Okay. While we know it's marijuana, and if you've ever been to a college campus, you know how that smell lingers. What we're looking for is the active ingredient, the active metabolite, that active impairing agency. That is time sensitive. That is critical. That is information that will change, and it will also change in the event of medical intervention.
But Ms. Lombardo, and this is in furtherance of Justice Doherty, I mean, I don't say this very often, but there's no exigency here. The blood was taken from the body, and it was preserved. So there was no metabolic dissipation of the marijuana or the alcohol or anything else possible. It was frozen in time because it was taken. And both police officers testified, said we could have gotten a warrant. We had time to get a warrant. We were relying on 3755. And as you note, Birchfield was emerging and our decision and Myers were emerging. I just don't know how both police officers say we had time to get a warrant and the blood was out of the body, so the metabolism wasn't occurring. And you can argue exigency with a smart face. And I don't usually say that kind of absolutism, but I think your better argument's on the other side, so I thought maybe we could take care of this.
Well, Your Honor, with that, I will keep my smart face and hopefully make a smarter argument about 3755. Give me that at least. All right, Your Honor.
Again, I don't mean to be impolite at all. I'm just, those are the facts of this case. You don't make them and we don't make them.
Well, I didn't make them in this case, Your Honor, but I will say this. Mitchell,
To the police officer to be commended for their candor.
and they should, and I think we don't want to ever become in a situation where we're asking court or officers to give false testimony to support exigency. I will note one practicality, though, of life on this front line. Until the vial is seized, it is not ours to control. We have had scenarios where blood has been drawn and lost or not given over. So when 3755 is still valid, and your Myers decision didn't implicate 3755, it didn't. When we look at Myers, Myers had a critical distinction, and that distinction is the phrase under arrest. That triggers the statutory right to refusal. That's, I think it's what, 1457, 1547? The numbers are correct, the order might not be, but that's the critical distinction, under arrest. Mr. Jones-Williams was not under arrest. That's why 3755 is the controlling statute.
So you're saying that notwithstanding Myers, notwithstanding all these other decisions, that you're insisting there's an implied consent exception to the warrant requirement as we sit here in December 2021?
I am, Your Honor. And I say that in two respects. One, when I look at your precedents, Pennsylvania Supreme Court precedents, I look at Rydell and those progeny of cases. They have not evisciated implied consent. And again, even Myers didn't evisciate implied consent. What they said was when an unconscious driver is under arrest, he still must be given warnings. And I think that's a fair distinction. But when I also look at the developing United States Supreme Court precedent, going at Birchfield specifically and at Mitchell, their decisions flat out say that nothing in those opinions should be construed in any way, shape, or form to decrease or devalue the importance of implied consent. They reaffirm the value of implied consent statutes. And you can also look at 3755 as a codification of Myers, or excuse me, of Mitchell, and what Mitchell stands for.
The difficulty, Ms. Lombardo, and this is a worthy case for your argument, and it's interesting, is that our statute does have implied consent. And then immediately below, it says that you can renege on your implied consent. You can refuse, and there's a collateral civil consequence if you refuse. And what this court has said in recent opinions is that when you look at the matrix of implied consent, right to refuse, that the legislature gave you both rights. And if you're unconscious, then you can't exercise the the second half of that, your right to refuse, and therefore that arguably nullifies the implied consent, because other than that, the right to refuse is just meaningless. And I think that's what you have to confront to get to be successful here. Do you follow what I'm saying?
If I may paraphrase your comment and question to make sure that I understand it.
Okay.
As Your Honor looks at 1547 and 3755 in a combined read in concert, they do create an implied consent, but part of that is you have the right to refuse. There's a statutory right to refuse. There is no constitutional right, but there is a statutory right.
Correct.
However, with the unconscious person who is unable to either consent affirmatively or say no, what does that mean in a post-Birchfield, Mitchell,
Yeah,
Myers
I
world?
think that's very well said. Does that nullify your implied consent? I think that's an open question, and that's what you're asking.
Well, I'm going to answer in two ways, because I think first is to answer in the way that reflects the question presented, and then to get at the heart of your question itself. And the reason I start with the question presented is we framed the question as Superior Court gave a speculative, prospective thought on what your honors would do based on Commonwealth versus March and Commonwealth versus Myers. I've discussed the distinction of Myers and this case and how the two are not factually or legally analogous. But March is particularly curious, as that was a grant, vacate, and remand in light of Birchfield and Myers. And from your precedent, we know that a grant, vacate, and remand is not a directive to go the other way or reverse yourself. It is a direction by this court to reassess in light of changes in case law, changes in circumstance. That court, please look at these circumstances. It may very well be that your answer is correct. It may very well be that your answer is wrong. That's the question presented, because that's what Superior Court did. They didn't say, the analysis Your Honor suggested. They said, we think this is what PA Supreme Court's going to do. Now, I don't have a crystal ball. I don't pretend to know what Your Honors are going to do, although I have some thoughts. But what I do know is, based on the precedent that Superior Court must apply, that was the wrong determination. To answer Your Honor's direct question of, essentially, can the unconscious driver, does implied consent survive the unconscious driver, the distinction comes with the distinctions between 1547 and 3755, and what those mean in those circumstances. 3755 is very clear. This is a non-arrest situation. So there's no statutory right there. You're not under arrest. Those warnings don't come in. So it does survive. It may be uncomfortable. It may cause some head scratching, but that is the way the legislature wrote it. So unless and until they want to make a correction, those are the statutes by which we are bound.
You're saying that manufactures an exigency? Is that what you're saying?
I'm going to help you. You're saying that therefore implied consent continues, notwithstanding no meaningful ability to withdraw it.
Correct, Your Honor.
Yeah, okay.
I think it's a fair summation.
In those cases where the
Follow that, David?
defendant is not under arrest.
Yeah.
Yes, because otherwise I'd be violating Myers, and I do not want to do that.
I think we understand that argument. Go ahead. And it is interesting that 3755 and 1547 have reasonable ground language and probable cause language and under arrest language. And that is a nuance that makes this even more complicated.
May I answer any more questions for the court? Thank you, Your Honors. It's been fun.
You did a nice job. Thank you.
We can always anticipate a spirited argument from the York County District Attorney's Office when Ms. Lombardo appears.
My bosses are watching. I'm not sure how they're going to take that.
It was positive.
You did a fine job.
Hopefully,
You don't invent the facts. Go right ahead.
hopefully this will be just as fun for me. Chief Justice, esteemed members of this panel, may it please the court. I believe, as the justices have addressed with some of their questions, I think clearly based on the facts and circumstances of this case, exigency was not met whatsoever. Certainly McNeely, Birchfield, and even the Mitchell decision, I think help support the fact that One of the valid exceptions to this particular area of law is consent or exigency. But again, those cases have all dealt with the consumption of alcohol and the dissipation of alcohol in an individual system.
I don't want to interrupt, but I just have a question.
Sure.
And I may have better directed it to the DA's office, but are police officers able to discern on an accident, I'm just curious about this, if they smell marijuana, whether in fact there's also alcohol in the person's system?
I've dealt with DUI-related offenses for the past approximately 15 years, and consistently in those types of situations, you will have officers both note an odor of alcohol as well as an odor of marijuana. And I think specifically at the time of this particular case, I think it's important to note that the Medical Marijuana Act had not been passed at that point in time. So the standing case law at that point was to the effect that if an officer smells an odor of marijuana and can confirm that the person is in actual physical control of the vehicle, that would be enough for an arrest. And as the court recalls from the facts of this particular case, there was no suggestion whatsoever from the multiple police officers that were on the scene of this crash, as well as the multiple EMTs and other witnesses to the accident, that anyone ever distinguished any type of odor of alcohol as it relates to this particular scenario. If the court doesn't have any additional questions as it relates to exigency, I would discuss the viability of Section 3755. And there is a presumption that when Section 3755 of the Motor Vehicle Code was passed, that it was constitutional. However, as the Superior Court addressed in their opinion and what the trial court urged in their 1925A, they pushed for the courts to find an unconstitutionality of not only 3755A, but its counterpart, 1547. And I believe the decisions that weigh heavily on that are not only Birchfield, but also this court's decision with Myers. Our argument was, at the time of suppression as well as on appeal with the Superior Court, that the testing of Jones-Williams blood was in fact in violation of the Fourth Amendment of the United States Constitution, as well as Article 1, Section 8 of the Pennsylvania Constitution, and that these implied consent statutes were no longer, based on those recent decisions, a viable exception to the warrant requirement. Dorward, Your Honor. And I believe as far as those statutes go, specifically, blood was drawn in this case as it relates to 3755. And there's no specific language in 3755 that the person must be under arrest for that to come into play. I would additionally note that with the United States Supreme Court decisions, and specifically in Mitchell, they addressed implied consent laws are a misnomer. That is, they are not a substitute for free and voluntary consent. I believe the courts addressed similar issues in the Myers decision. They went on to say that our decisions have not rested on the idea that these laws do what their popular name might seem to suggest, that is, create actual consent to all searches they authorize. So again, referencing on that particular language from the United States Supreme Court, as well as some of the information and language in the Myers decision, I believe that gets us beyond the implied consent statutes, and that as of December 8th, 2021, as we sit here now, implied consent is no longer viable as a valid exception to the warrant requirements.
I think in fairness, that's what we're arguing Doesn't talk about implied consent, doesn't talk about a right to refuse, doesn't talk about any of that. It merely says that if there's probable cause to believe that there's a violation and the hospital has taken the blood, the police can get the blood, in making it very simple.
That's correct.
So if you read 3755 and knew nothing else about our case law and statutory law, you would say, well, this is what the police did here is just fine. The reason it's not fine is he never had the opportunity to decline the blood test because he was unconscious.
That's correct.
Okay. So you do get back to implied consent, right to refuse, inability to refuse, don't you?
I believe we do, but I think as this court addressed in Myers, an unconscious person cannot give actual consent. There is no actual viable consent that the unconscious motorist is able to provide in those sets of circumstances.
I'm not sure we're going to get the answer, but I'll actually only one more time. Again, and I have the benefit, I'm looking at 1547A and B1.
Yes.
A says there's implied consent. B1 says if a person is under arrest and requested to submit to chemical testing and refuses, then the test shall not be conducted. And so you come back to the idea, and I don't know the answer to this, but that's why we have oral argument,
Right.
that your client wasn't under arrest, and that changes things. I think that's the argument, if I understood it from York County.
And I think as far as if the court's weighing in on the actual arrest decision, part of the concern with all of that is the facts and circumstances of this case are that when Sergeant Lutz or Lieutenant Lutz was on scene, he directed Sergeant Farron to go to the hospital for a legal blood draw. Their specific intent at that point in time was to place Mr. Jones-Williams under arrest for suspicion of DUI. When he arrived at the hospital, the testimony provided at suppression was that he attempted to read the DL-26 form, which advises the individual that they are under suspicion of DUI, they're being placed under arrest for that, and they're requesting the person to submit to a blood draw. It was only at that point in time when Mr. Jones-Williams was in and out of consciousness, I believe due to the medical issues that he was dealing with at that point in time, and I believe there was some reference that he was given Haldol by...
Your argument is you can't arrest an unconscious person because you can't tell them that your liberty is constrained. Right. Their liberty is constrained by their unconsciousness.
Well, and I think for all intents and purposes, Mr. Jones-Williams, in effect, was essentially placed under arrest at that point in time. It was beneficial to the Commonwealth to not arrest, and I believe it was over a year until they actually pressed charges so that they could further facilitate their investigation.
Counsel, Justice Donahue here, just explain to me what difference from a Fourth Amendment perspective it makes whether an individual is under arrest or not.
I'm not aware of one.
Isn't that the answer to the question that Justice Baer just asked you? What difference does it make? An unarrested individual has Fourth Amendment rights.
That's correct.
Does she not?
Yes.
And he's just as unconscious in the one scenario for Myers' purposes as in the other, right?
Correct.
Yeah. So the fact of the non-arrest does not bootstrap an exigency that didn't already exist.
That would be our position.
Thank you.
Anything you'd like to add in summation?
No. Thank you very much.
Did you have fun? Did you have fun?
Not bad.
Muhammad versus Strausberger case, holding that a dissatisfied client may not bring an action against their attorney following a settlement to which the client agreed absent fraud. And we granted allowance of appeal in this legal malpractice case, which is a Muhammad case, to consider whether Muhammad should be overruled, or alternatively, whether this case is distinguishable from Muhammad and should be permitted to go forward notwithstanding the Muhammad decision. And I might add that it seems to me that one of the corollaries is if this case is distinguishable from Muhammad and may go forward notwithstanding Muhammad, then we may not ever reach the issue whether Muhammad should be overruled. And with that, Ms. McMichael, feel free to go ahead.
Your Honor, Virginia McMichael, counsel for the appellant, Dr. Alam Khalil. As Your Honor framed it, we do have two issues here. And if the court should decide that the Superior Court erred on the specific issue involving this case, you need not get to the viability of the Muhammad rule. But the specifics of this case inform the analysis of the larger case. So I would like to address that one first so that we're all on the same page as far as what happened in the trial court and in the Superior Court.
I'd only caution you, I promise you, you have a complicated factual scenario here with two lawsuits and counterclaims and cross-claims and additional joinders of additional defendants, and we all know that. We all took the time before you got here to figure out the case. So go ahead.
Thank you. Well, I will therefore get right to the issues, and I was not going to belabor the facts. But first of all, the Superior Court erred as a matter of law when it held that Dr. Khalil's claims in this case were barred by the Muhammad rule. Muhammad was intended to prevent plaintiffs from suing their lawyers when they have buyer's remorse and are dissatisfied with the dollar amount of a settlement. This case is not one of buyer's remorse. Dr. Khalil's legal malpractice claims are grounded in her lawyer's mistakes in negotiating and recommending that she sign the traveler's release and submitting that release to the court. Dr. Khalil was injured when the language they agreed to and recommended she sign as part of the traveler's release was later construed by the court in Pier 3, the other action, as releasing all her claims against the condominium association. As discussed in our brief, this case falls squarely within the exception to the Muhammad rule that this court adopted in McMahon, and also the Superior Court adopted before that in Collis versus Garnick. Nevertheless, the trial court, in its opinion, ignored both McMahon and Collis and held that Dr. Khalil's legal malpractice claims were barred by Muhammad. And that decision reflects a basic flaw in the construct here that was created by the Muhammad rule. A busy trial court judge will remember and apply the general rule, which of course in this case is Muhammad bars post-settlement legal malpractice claims. But it's very easy for a busy court, who may not have as many law clerks as would be helpful, to miss and ignore various court-made exceptions to that general rule. And in this case, although the summary judgment papers really did go into the Collis case, and that was raised in opposition to summary judgment, the trial court nevertheless applied the general rule and held that Dr. Khalil's claims, legal malpractice claims, were barred. And then for its part, the Superior Court acknowledged that Collis and McMahon are good law, but Muhammad did not establish a blanket rule barring any non-fraud claim against a former attorney when the matter led to settlement. But the court then relied on a very narrow reading of the complaint to support its conclusion that the complaint failed to plead facts that fall under the negligent advice exception of McMahon and Collis. And it's our position that the Superior Court erred as a matter of law, and this court should reverse. The Superior Court erred when it held that Dr. Khalil's claims do not fall within the, we'll call it the negligent advice exception, for lack of a better name, to the Muhammad rule, because the gist of her claim lies in fraud. But Pennsylvania is a fact pleading state, not a theory pleading state. And a complaint can allege different legal theories that depend on different facts. And in this case, there are two sort of broad theories of the case that are alleged in the complaint. And the first the court focused on, the Superior Court focused on, was the fraud theory. And that's premised on Dr. Khalil's belief that she signed a release with an asterisk that clearly carved out her claims against Pier 3 and the other action, but somehow the release was switched, and the one that was submitted to the court was...
That case is proceeding in any event. The Superior Court reversed on that theory, did it
Yes,
not?
yes.
Yeah.
The Superior
that's not
Court
before us.
left in count 5, but I'm just trying to
Yeah.
get the bigger picture here. And then the negligence theory is the other 4 counts, and that was based on the advice that she was given in connection with the settlement, and those are the counts that the Superior Court held were not adequately pleaded in the complaint. In Pennsylvania, the assertion of facts in one claim or theory doesn't preclude inconsistent facts. There's a Superior Court case, Barron versus Bernstein, we discussed it in our reply brief, that addresses this. And in Barron was a petition to open a judgment. And the petitioner alleged that the judgment should be opened because he performed his obligations under the agreement. But he also alleged that he never signed the agreement, the original had marks, not on this copy, and that his signature was forged. Obviously inconsistent factual allegations. The trial court found the petition to be untrue and dishonest, dismissed his petition, and the Superior Court reversed, holding that pleading, although inconsistent, was not defective because the petitioner can assert inconsistent theories or facts. And here, the complaint alleges facts that support Dr. Khalil's claims that the lawyers were negligent. And we do discuss that fairly in great detail, I think, in the brief and the reply brief going through the various allegations. So I will not reiterate that here because it's all there in the complaint. But simply put, the Superior Court's conclusion that Dr. Khalil did not plead facts to support a negligence claim are simply not supported by the language of the complaint.
So, Counsel, if this isn't, it's Justice Donahue, if this isn't a Mohammed claim, why would we consider overruling it in this case?
Well, it is a Mohammed claim because the Superior Court's decision said that the first 5 counts of the complaint were dismissed based on Mohammed.
What difference does that make to you? You're still proceeding with your claim against the attorney.
Well, what we have left after the Superior Court decision is just one claim, and that's only the fraud claim, whereas we think that there are very valid claims supported by the record. In fact, most of the facts are undisputed about the lawyer's negligence, and that's really the essential part of the case.
But we could correct that by saying the Superior Court erred in not following the exception based upon negligent legal advice.
You certainly can decide this on that specific issue, and that's why we want to address both.
We could also do away with this process of having to parse through these exceptions, do away with Mohammed entirely so that the courts wouldn't be forced into the business of saying, oh, is this a Collis exception, is this a McMahon exception, and rather let the cases rise or fall on their individual merits.
That's exactly right, Your Honor. And I think where we are now is we have court-made exceptions to the Muhammad rule.
And there's no end to that. There's
Right.
no end to that. Parsing and trying to find some distinction rather than confronting it head on.
And it also makes it harder for trial courts because then they have to say, okay, what was the most recent decision on this? Did the Superior Court create another exception? And the problem with having a broad, harsh rule, which really Mohammed is and has been recognized as that by courts throughout the country, is that when there's a meritorious claim, the trial courts and the Superior Court are saying, okay, there's got to be an exception here that this will fall into, and so new exceptions keep getting
Ms.
created.
McMichael, let me explore further Justice Weck's question, and I mean this sincerely. I need your help. We granted aliquotter on 2 discrete issues.
Correct.
The second issue is whether the Superior Court misconstrued the averments in the complaint, and as you say, the Callis and McMahon exception applies. If we find that so, isn't a ruling overruling Mohammed just all pure dicta because this is an exception to Mohammed and you never get there?
I think that's correct, Your Honor. Quite frankly, I think that we should win on the facts of this case.
I may be with Justice Weck that I'd like to get a Muhammad case, and because it's been so roundly criticized all over the world, and I thought we had one, and then in getting ready for this case, as I just asked you, I sort of came to the conclusion that this may not be the right case.
Right. Well, I was aware that this court was looking for an opportunity to address Muhammad, and in fact, a couple of years ago, had granted an appeal on this same issue, and that's why we're here in part.
Yeah.
But
you wouldn't mind Muhammad being overruled, but what you really want is your lawsuit to go forward, and your argument is your lawsuit can go forward regardless of Muhammad.
well, that's certainly my client's interest, is to get this back in the trial court where it belongs. It does, the specifics of this case do illustrate the problem with the Muhammad case, and that is the creation of all these exceptions, just as Justice Weck pointed out. And, but it's a question of balancing interests. On the one hand, the court doesn't want to encourage people to bring lawsuits just because they're unhappy with the dollar amount of the settlement, the buyer's remorse problem.
But aren't you giving more credit than you need to the I mean, as if something this court does is going to encourage or create, foster some cottage industry of suing lawyers. I mean, I'll wait for opposing counsel to argue, because and let me stop there. It's just that I wonder whether this case doesn't further illustrate the problem with this kind of blanket immunity.
I think it does, and I think that the blanket immunity throws out a lot of meritorious legal malpractice claims, and that's why we see all these exceptions. I mean, there's one case, Reynolds versus Stambaugh, where the Superior Court found that the paralegals, false statements about the status of the case and the lawyers trying to insinuate himself in the settlement all sort of fell within the fraud exception. I mean, I think there's efforts to pigeonhole, find something to put this under so that the meritorious claims survive that ban. I mean, I've been struggling with what would be an alternative here.
And on the issue, which again I'm not convinced we get to, but of Muhammad's viability, it appears that most other states have rejected the rationale, and they have not imploded because of legal malpractice litigation.
I think the argument the other side would make, it would encourage litigation. I do agree with Justice Weck. I don't think so. I mean, I think all the television of lawsuits and making it look so glamorous probably encourages more litigation than anything this court might do on this particular issue.
Counsel, could you state for me your view of what the holding of Muhammad was?
The narrow holding of Muhammad.
The only holding of Muhammad.
The only holding of Muhammad.
Yeah, that's what I'm trying to understand.
Is that claims, post-settlement claims of legal malpractice are barred absent an allegation that there was fraud in the inducement. Which I think would be a scenario where the lawyer knew they really messed up. And the only way to sort of hide that is to encourage the client to settle, and maybe settle for less, because otherwise their malpractice is going to be exposed. I think that's what the court was addressing with the fraudulent
I'm going to remember
inducement.
that, and then I'm going to ask your opposing counsel that same question, i.e. what was the actual holding of Muhammad. Did you file a certificate of merit in this case?
Yes.
Okay, now, when Muhammad was decided, am I correct in saying there were no certificates of merit?
Correct.
I have not looked into that issue, Your
There were
Honor.
not, correct?
I believe there were not.
Okay, now doesn't that make a difference in our landscape?
Yes, it does. And I think that if the court still has an interest in preventing the dissatisfied with the dollar amount of the claim sort of case, that there are a number of thresholds to prevent that. The certificate of merit, expert reports, both go to that. And the other thing would be to come up with a principle perhaps of a rebuttable presumption that if somebody is bringing a lawsuit after the case is settled, that there is a rebuttable presumption that they're just unhappy with the dollar amount of the settlement,
Now, why would
and that
we-
they have
why
to
would we
prove
do
that they're not.
Why would we do that? I mean, isn't that another exception?
It is.
I'm not convinced one way or another what we should do with Mohammed, but I do know if we overrule it, we have to consider what that's going to mean. Okay, now, let me ask you about one of the cases that was probably the most critical of our court's decision in Mohammed, which came out of Maryland, Thomas versus Bethea. You're familiar with the case? What intrigues me about their critique of our Mohammed rule is that their rule makes it almost impossible for a plaintiff to win a legal malpractice case. Their standard is no reasonable attorney, having undertaken a reasonable investigation into the facts and circumstances and with knowledge of the same facts, would have made the recommendation to settle. Okay, now, I mean, if we adopted something like that, we would have to change our certificate of merit rules as to attorneys. That's number one. Not only do they do that, but they also require a trial within a trial, as we do. I mean, so, I mean, their rather pointed critique of Mohammed, lets you ask afterwards, and how is it that we're doing is any better than what we did with Mohammed? And
Right.
if someone's concerned about some notion that we're attempting to protect trial lawyers. So what do you think we should do if we consider Mohammed overruling it?
Well, I think that it is not inappropriate to apply the same standard to a legal malpractice action after a settlement as you would apply to a legal malpractice action after a full trial. Because if there's a full trial and the client says, oh my gosh, my lawyer didn't put on the key witness, or some other trial mistake, then you do have that trial within a trial to show, but for that mistake, they would have gotten a better result. I mean, you have to prove that there was an error, you have to prove causation, there was a proximate cause of the injury.
Would you keep a trial within a trial? Because that's just as criticized as Mohammed is.
Well, you still have preliminary objections and summary judgment. I mean, there are various stages of a case that if the plaintiff did not allege something that rose to the level of malpractice, they wouldn't get beyond that threshold. So they have to go pretty far before you get to the point where there's a case within a case. I think.
So you prove malpractice by way of an expert. You file a certificate of merit in advance that says, I have somebody who says this was malpractice. And then you only recover if what? The jury decides that the amount of the verdict would have been greater if they tried the case, or the amount of the settlement would have been greater under certain circumstances. You see my problem. I mean, that's why I'm asking the question. I mean,
Or the amount of the settlement was simply unreasonable.
yeah, I mean, overruling Mohammed raises interesting questions. And maybe the question is, we don't care. Maybe we just say, try the case. I mean, and let jury figure out what the right result is here. But no other jurisdiction does that. Just because of the differences involved with advice on settling a lawsuit for a sum certain.
Well, I think the challenge of challenging a settlement is that there's so many factors that go into a settlement. They're going to the lawyer is going to make a settlement recommendation based on the legal merits of the case, based on whether his or her client is going to be a good witness, based on, the resources of the defendant. A whole bunch of factors come into that. So I would think that there's a large range of reasonableness for a settlement, and that a trial court is going to, if confronted with evaluating a situation, say, yes, but even if they made a mistake, that settlement was well within the range of reasonableness.
And that settlement would, I presume, act as a set-off. If you got anything in the second trial, if you settled for $30,000 and when it was all said and done, a jury decided your case was worth $40,000, you don't get 40, you get 10, because you've already gotten 30 on your claim.
Correct, Your Honor.
So-
The other thing to
It seems like
consider,
there's so many roadblocks along the road that
There are.
I don't know how much Muhammad matters or doesn't
well,
matter.
the other thing to consider, Your Honor, is the cost between settling early in a case and taking it all the way to trial. You've got a lot of attorney's fees that are racking up. So
And expenses of experts.
and expenses of experts. And so that comes into the equation. Oh, yes, you got $10,000 more, but you had to pay $75,000 to get there. So with the range of reasonableness is like, well, that didn't make any sense. So there are a lot of variables here. It makes it very difficult to apply, I think.
Anybody? Well argued, thank you. Mr. Khan?
Oops. I'm sticking to the.
Chief Justice Baer, Associate Justices, may it please the Court, James Kahn of Margolis Edelstein Firm for appellee defendants Gerald Williams and Beth Cole, who are sitting there, and their prior law firm. This case, in this case, as Your Honor noted, Judge Foglietta properly found, and that was proper, within his discretion, and then the Superior Court affirmed that this was indeed a case where Dr. Khalil was attempting to second-guess the amount of her settlement, as stated on page 20 of Judge Foglietta's opinion, and then which was then affirmed by the Superior Court. Superior Court affirmed Judge Foglietta's decision and also examined the allegations of the complaint, as is discussed on page 19 of the Superior Court's decision. And the Superior Court found, upon examination of the complaint, that in paragraphs 19 and 20, Dr. Khalil alleged that she refused to sign a release unless it had language that she wanted, and that's what she signed. And then she goes on in paragraph 33 to allege that the release was switched, specifically a page of the release, the first page of the release, and as a result, that the wrong release was given to travelers. Thus, the Superior Court held, and rightly so, that the claim was about fraud and not negligent advice.
Counsel,
And thus, Muhammad barred the claim.
share with us, am I mistaken when I read that the facts before the trial judge and what's before us is that when the doctor reached out to counsel, her attorneys assured her on multiple occasions verbally and more importantly in writing that the settlement would not impact her other suits because she had different insurance plans and claims?
That's not exactly correct, because what they assured her was that it would not affect claims that were not the same claims, that you couldn't assert the same claims as counterclaims in another suit. She still had and was able to proceed with claims that were not barred, claims that would have to do with whether the condominium could deny her rights to her property or the common property.
Is that in the record, Mr. Khan?
Yes.
That if it eluded me in preparing for the case, that her counsel told her by signing the general release in the water damage case that she would be waiving certain counterclaims in the Pier 3 rental case because they were the same claims.
Right, but what they told her was that she had claims preserved. There were other claims. She had a claim against regarding her clothing and such that went to trial, and she was able to recover.
Where in the record's all this?
Pardon?
Where in the record is this nuance that, in fact, they gave her correct legal advice, they told her, and this put aside her argument of switching of documents. We don't care about that. That's in the trial court to figure out at this juncture. Where in the record does it indicate that their legal advice to her was that she should sign the agreement and settle the, I guess it's, I named them things, the water case, the water damage case, notwithstanding that it would be a waiver of some of her counterclaims in the Pier 3 case.
Well, I think that's in the summary judgment record. I don't have the specific site, I'm afraid, but that's what it was. And in fact, there's records, the other cases that went forward.
Is it in an affidavit that your clients put into
It's not an
summary
affidavit.
judgment or a deposition?
It's in deposition testimony.
A deposition?
Yes.
Is it a contested material fact or an acknowledged material fact?
Well, I think that would be contested.
Therefore, you don't get summary judgment on it. In other words, the plaintiff's contention, I don't know what happened here, obviously. Plaintiff's contention is that she was very concerned that she did not want to waive any counterclaims in the Pier 3 case, and that she was assured that by signing a general release in the water damage case, she would not be. What you're telling us is the flip side of the coin, that she was told in the water damage case that when you signed the general release, you would be releasing your counterclaims to the extent they were on the same factual basis.
Right, she couldn't recover twice.
And that just surprises me. That's like we can't agree if it's raining outside or if it's daylight outside. And that's why I'm exploring whether or not that's really a resolved issue in the case, and if it's counter averments in a summary judgment, it's obviously not a resolved issue.
Right, well, the summary judgment was granted by Judge Foglietta based upon his judgment that what she was doing was second-guessing, that it fell squarely within Muhammad. That was not an abuse of his discretion and was affirmed by the Superior Court, which also found that the allegations of the complaint tended toward not negligent advice, but this fraud claim. There's nothing in the complaint that talks about an alternative scenario or an alternative theory. There's one theory, and that theory is that the release was switched. And thus, the Superior Court said, we'll go ahead with that on count 5, but there's not really a negligent advice case because no one's saying that, oh, there's an alternative theory that the release wasn't switched, and thus I got negligent advice about that.
Well, but isn't there...
Doesn't this illustrate
You're next.
that Muhammad is not, to the extent there was a viable reason for it, it's not serving its purpose of avoiding litigation. We still have a morass of factual allegations that are going to be hashed out. And on top of that, we've created a paradigm where there's artful pleading to try to get it out of Muhammad, get it out of contract, get it out of negligence and into fraud, such that the whole purpose of this immunity rule is disserved. Instead of fostering litigation costs around whether there's an exception or not an exception, or whether we can differentiate it or distinguish it, why don't we let this be treated like any other species of malpractice case and let it be fought out on those grounds, since we're still getting litigation anyway? What's the reason for this protective rule?
Here's the reason, Your Honor. If someone has a problem with their case, it may be a liability problem or a problem that should lead to very little damages. The plaintiff settles the case. Then they get a second bite of the apple because they get to keep the settlement amount, which is an offset, as Justice Baer pointed out. But still, they get that second bite of the apple, and maybe in that second case within a case, they overcome those problems and they can get more money. It's going to lead to a lot of cases like that. That's the problem.
Well, I get a surgery and I get a good result from my surgery, but I'm not happy, so I sue a doctor, right? I still need to get a certificate of merit. If my case is garbage, it's going to get thrown out. Why doesn't the same apply to lawyers?
Well, lawyers, you do have to have a certificate of merit, but it would be very easy to get a certificate of merit.
Why is that?
Because there's a lot of lawyers in the Commonwealth who grant certificates of merit.
And that's different from any other species of malpractice?
I do believe that it's very different than what doctors do with certificates of merit.
Doesn't it look a lot like us protecting our? Doesn't it look like us protecting our own?
Well, it could certainly be interpreted that way. I grant you that. But there's a reason here, because it's not just protection of lawyers, it's protection of lawyers who entered into settlements. That's a unique thing.
Counsel, if I may ask a question. Going back to the summary judgment and the second question we granted as to whether there was an error of laws granting summary judgment regarding the legal malpractice. Now, both the trial court and the Superior Court, my understanding, believed that there was a stipulation as a fact that there was no material controlling fact of dispute. But that's not what you just said. So the way I see it, if we follow your argument, then you've admitted that there's a material fact disputed such that it's an error of law for the trial court and Superior Court to have affirmed the summary judgment. So I ask you, is your comment today the truth, or is the statement to the court through depositions correct? Because you can't have it both ways.
Well, I think I answered the question from Chief Justice Behr, but that's not a relevant issue here.
It's the second question that we granted Alicotter. Did Superior Court misconstrue the environments, which is your complaint, as an error of law when it held that the doctor's legal malpractice claims were barred? So the reason they said they were barred was because there was no material dispute of fact. But that's not what you just said here. So the question I have is, did the lawyers put in writing that Dr. Khalil could pursue the general release of the settlement and that it would have no effect on the counterclaims of the Pier 3 lawsuit?
I don't have a writing specifically stating it that way, but what the Superior Court found, respectfully, Your Honor, was that the allegations of the complaint were of the nature of fraud and not negligent advice, because there was a single theory of a release switch and that it was fraudulently released. Not that there was any alternate theory in the complaint that there was bad advice about a release, which she claims she isn't the one about the release that she signed and wasn't used.
Collis and McMahon permit an exception to Muhammad for lawyer negligence, legal malpractice. So let's step outside the fraud. We can concede that the fraud's not issue. What's at issue is the pursuit of a legal malpractice action. And I ask you one more time. Summary judgment was granted on that based upon Muhammad, the legal malpractice. Today you just said there's a dispute as to the material fact as to whether the lawyers did or did not provide appropriate counsel telling Dr. Khalil to settle in to her general release because it would have no impact or cause any concern with her in the pursuit of the Pier 3 claims. So it's a really simple yes or question. Either they concede that they did do that, or you're telling me that they didn't. If they did do that, then that meets and overcomes as an error of law that the case should proceed. And if you're saying that it does not, then it's an error of law of Superior Court to have found such a finding when you're articulating to the Supreme Court that there is a dispute. I perceive this as a very direct question that's important to our decision today.
Right. Well, I'm not saying that the plaintiffs have conceded anything, but what I am saying is what Judge Foglietta found was that the case wasn't about the advice, it was about the plaintiff, Dr. Khalil, second-guessing the amount. From her June 2011 letter saying she had a dispute with the condominium and she didn't want to settle anymore, she didn't want to do a settlement even though she had signed it, and then on and on. The stuff about the advice came, like was mentioned much later, and what's mentioned in the reply brief came much later in August. And what Judge Foglietta found within his Honor's discretion was that this was a case about second-guessing the amount. That's specifically what he held.
I have to say that my reading of this record is diametrically opposed to what you represent, and I say that respectfully. As I already asked you, Justice Doherty just asked you, I mean, you're not going to slip one by us. We look at these cases very carefully and we write. And my review of this record is that Dr. Khil's concern was the waiver of counterclaims in the Pier 3 case. I've never heard that she was dissatisfied with, I think it was an aggregate $107,000 that she got among all of the defendants, one pre-trial and one during trial, in the water damage case. You're telling us that she wants more money in the water damage case, and I don't think that's so.
Well,
I'm bothered by that.
Well, that is specifically what Judge Foglietta said, very specifically what he said on page 20 of his opinion. And then the Superior Court has upheld that, also pointing out about the allegations in the complaint only dealing with this release switch, which is a fraud and not negligent advice. And there's one theory the complaint doesn't allege that, oh, in the alternative, I got negligent advice if that's the release I signed.
We'll go over the record and we'll
Of course.
figure this out.
Of course. But I was speaking a minute ago about the importance of Muhammad. And it does, I mean, maybe it needs to be clarified. That's perfectly fine. But what it does do is it protects lawyers, which are in a unique position, which the Muhammad court at that time ruled that settlements were important, that settlements needed to be protected, and that allowing what are called settle and sue cases would undermine that terribly.
But life-saving surgeries are also important, but we still allow suits against physicians.
Of course, and that's
Why are
very
lawyers
good.
special? Why are lawyers special?
They're only special when it comes to settlements. That's where they're special. That's the issue. That's what the Muhammad court saw as a problem. That settlements could be undone. It would discourage lawyers from entering into settlements. And also, we submit in the Pennsylvania and Philadelphia and Allegheny County Bar Associations have also stated that this would cause a lot of cases to get a second bite of the apple. There's no second bite of the apple for a doctor. You can't accuse the doctor of somehow being negligent in getting his lawyer getting a settlement. It doesn't work that way. It's only in these lawyer cases that can happen. That's why they're unique. That's why we're not making special treatment for lawyers. We're only making special treatment for the situation involving settlements. And that's why this doctrine is very important. It may need to be clarified. Any law is subject to a slippery slope, but that doesn't mean we don't need laws. We need to have laws that are, properly interpreted, and we've had cases, of course, in McMahon where there was different opinions and a split. That's, happens, but it's not useful to the development of the law. But the law needs to be developed. It should be developed. And going back to the other issue, the first issue, although let me just one bit of background. There's been so many litigations, and they're stated in the record and in appellant's brief. That's why this has to end. That's why the Common Pleas Court found that it was just second guessing and ended the case. The Superior Court upheld that and also looked at the allegations. There's too many suits, and this multiplicity of suits is exactly what...
You keep saying that. If I read the record correct, the question from the court was, whose concern is this signing of the general release? And and the court said, yours or your clients? And when you said your clients, or the lawyer said your clients, the judge's response was, which I interpreted in a very sarcastic and condescending tone, what law school did she go to? Is that true? Did I read correctly from the documents you provided us? And if that's the basis, is that the basis for Judge Foglietta's decision?
Judge Foglietta did not say that in his opinion.
That was what was submitted on this record. So maybe you should read your own record.
We'll go through the record.
Okay, thank you.
Any closing comment?
Yes, as I was...
Briefly.
Right, briefly. If there's questions about Muhammad, it needs to be clarified. If there's questions about what the Superior Court did in its decision about judging the allegations of the complaint, then the case would need to be remanded to the Superior Court to consider the record as Judge Foglietta found it. Because if that would have to be done.
Just in closing, we've read this record. We know that Dr. Khalil likes to litigate, and perhaps or perhaps not abusively, but that's not the issue before us. We have a very narrow legal issue as to whether or not this case can go forward. So,
And sir, just for the record, page 21 of appellant's brief, or as well as 429A through 432A of the record in quote-unquote the court. So what law school did Dr. Khalil go to? I missed that part.
Right,
Just
well,
letting you know.
that wasn't Judge Foglietta, that was another judge.
Oh, okay, then I apologize.
Right, no, that's a whole nother judge. I mean, one of the issues in the case, I'm sure your records reviewed, is that this case has been handled by about a dozen judges at least, not counting appellate judges.
But the question was regarding the general release signing for the legal malpractice claim for which summary judgment was granted, just so that
Right.
we have the record.
But that became irrelevant when the Superior Court held that the collateral estoppel didn't apply. What Judge Foglietta held had nothing to do with that, but only that he found that looking at the entire record and taking his time, and there's nothing that he didn't, was too busy, that's just not, there's nothing of that, that it was really a second guessing. And that was not within an abuse of his discretion. It shouldn't be questioned. The Superior Court didn't question it, but also talked about the allegations.
we'll go through the record and straighten this out. Thank you very much for your argument. Revisiting, as so many of cases today have familiar topics. In several cases, the Commonwealth has held, this court has held, I mistyped in my own notes, this court has held that suspensions of defendants' driver's license and privileges imposed after an extraordinary delay of time from conviction until notice to the driver of suspension, coupled with the driver having no further material infractions and being prejudiced by the delay, renders the suspension improper, regardless of why the Pennsylvania actors necessitated or caused the delay. In this case, the defendant was convicted of a DUI in Florida in March 2013, reported to PennDOT in April 2016, a delay of 37 months. The driver's license, interestingly, had already been suspended, although I don't think on this record we know why, for 23 months because of, quote, information received from Florida. The trial court vacated the driver's license suspension arising from the 2013 DUI, and Commonwealth Court affirmed. PennDOT now appeals, arguing that that Florida was responsible for the delay between the conviction and notification, and that under the driver's license compact among states, we should reverse the lower court and reinstate the driver's license suspension. And if that's pretty close, Mr. Bricknell, feel free to go ahead.
Thank you very much, Your Honor. May it please the Court, my name is Philip Bricknell. I represent the Department of Transportation Bureau of Driver Licensing. And this case is really about the narrow issue that the Court granted aliquotter for was the narrow question of does it make a difference who delays the report of conviction or who delays the imposition of the suspension. PennDOT argues that it does make a difference, and it makes a difference in this case because as Justice Bayer just mentioned, this case follows a series of cases that have looked at what happens, how the delay should be treated depending on the length of time of the delay and various other factors. All of those cases were trying to correct a problem that was created by the clerk of courts, primarily in 2 counties. One was York County, which led to the Gingrich case, in which 5,000 convictions were delayed in being reported for almost 10 years. And the second county was Delaware County, where the majority of the progeny of Gingrich emanated from. It's about 3/4 of those cases. This court and Commonwealth Court have made their decisions, came up with the 3-factor test, and then modified that with the Middaugh test, the bright line rule for Middaugh, to address that problem, to try and rectify a problem that was happening in the judiciary in Pennsylvania. Therefore, those opinions can be said to make sense in trying to correct a problem that happened in Pennsylvania. It doesn't make sense to try and impose those correctives on another state where this court, nobody in Pennsylvania, nobody in the Commonwealth, has any real influence over what Florida does. So there are 5 reasons why this court should reverse Naginey. The first one is that, as I said, we don't really have any jurisdiction or control over what Florida does. We don't know why Florida delayed the sending of that report of Mr. Naginey's conviction for DUI. Number 2 is the large number of DUI reports Pennsylvania receives from out of state under the driver license compact. I think it's 46 or 47 of the states are signed on to the driver's license compact. In our last normal year before the pandemic, 2019, there were 1,700 out-of-state DUIs reported to Pennsylvania. And it's just the nature of the various states' DMVs that they focus on their own state's drivers and reports and processing of out-of-state convictions.
Mr. Bricknell, can I interrupt you for a second? And this is, again, probably the 3rd of these cases we've heard relatively recently. What, respectfully, PennDOT seems to not fathom is it's not the sentencing judge in the criminal matter arising from the DUI. This gentleman and everyone convicted of a DUI gets a criminal sentence arising from the DUI. PennDOT's purpose, and we've written this, is to keep our roads safe. And the fair inference is that if someone just had a DUI, we don't have confidence that they're not going to drive again under the influence immediately thereafter. So we take their license away to protect all of us and all of our citizenry from a drunk driver. But if they've not had another DUI or another material infraction for 3 or 4 years, then the underlying purpose of taking their license is gone. And it seems that you want to be, respectfully, a corollary criminal court and punish them. Now, why is that wrong?
I disagree with that, that view of the situation. PennDOT is not the aggrieved party here. The General Assembly is. It's the General Assembly that set up the vehicle code and set up the terms that are in the vehicle code. PennDOT is merely tasked with not enforcing, but applying the vehicle code. And the vehicle code simply says if PennDOT receives a certified report of conviction, not one that was timely reported, but just simply receives a report of conviction, it shall impose a suspension. And that's what PennDOT does. It's the General Assembly who decided in the case of suspensions, particularly for DUI, not to set any limit, any time limit, anything like a statute of limitations. The General Assembly took a different approach with the points that drivers can get on their licenses. Under Section 1535 of the Vehicle Code, if a driver accumulates points or gets points for a stop sign violation, and those points are not reported to PennDOT within 6 months, they don't go on the driver's record. So the General Assembly, if they wanted to, can put a limit on the implication or the imposition of a suspension, but they chose not to. And so it is the General Assembly that set this up. PennDOT, and just to speak on behalf of my client, PennDOT takes no pleasure in imposing licenses, suspensions, or taking them. It is simply doing what the General Assembly set up and asked it to do. And this really sort of opens.
I'd only point out that, and I think that's a good answer, Mr. Bricknell, that we've decided a series of cases, and the intermediate appellate courts have, and to date, there's been no legislative response, and they're certainly free to respond, and we don't begrudge that, and we follow what they say. They're the policy-making branch of government.
That's right, Your Honor. And actually, even under Gingrich and Middaugh and those cases, my advice to my client is still the same. The vehicle code still says if my client receives a late notice of conviction, it imposes the suspension. What Gingrich and Middaugh have set up is a way that a driver who has means may be able to appeal it and get out of that suspension.
Right.
And that I think does actually get to something that does concern my client, which is the Gingrich and Middaugh line of reasoning really undermines the way the vehicle code is set up to operate. The vehicle code is set up so that the same violation results in the same sanction. And under the Pocoy rule, that's what happened. It didn't matter if PennDOT didn't cause the delay, if we got a late notice of conviction, PennDOT imposes the sanction regardless of how long after the event it was. That has now changed. As I said, now under Gingrich and Middaugh, if there's a late sanction report of conviction, somebody can get out of that if they meet certain factors, if they can afford to fight it, as Mr. Naginey has here, and if they can, initially, if they have the lucky windfall of somebody not reporting the conviction to PennDOT.
Not to beat the dead horse, but I don't know that I like the language they get out of it. What's happened is that its underlying public policy purpose is no longer there, again, because of the fact that they have to be prejudiced and the fact that they have to have a clean driving license in the interim.
Well, perhaps, Your Honor, there's a sentence in this court's Middaugh opinion that mentions that there are actually two benefits to the suspension. The first one is remedial, and that's what the appellate courts have focused on, the length of time. Time has passed. Does it make sense to take this person off the road for a period of time? The other part, though, the second part, was the deterrent effect, and that got one sentence. And there's been no real discussion of the deterrent effect of a driver's license suspension or sanction. And that is unfortunate because it is the deterrent effect that often has a huge impact on drivers. Because it isn't just the driver that's going to lose the ability to exercise their operating privilege on the road for that year. Everybody in that driver's circle is going to be affected. People in that household will have to change. Friends will have to give lifts. It's not uncommon in appeals at the common pleas level of a driver license suspension to have a appellant there fighting their suspension, saying they will lose their job, they will lose their mortgage, they will lose their spouse if they get the suspension. So this has a huge effect. And what has happened with Gingrich and Middaugh is now there's a way to get out of that if you have some means, the way to avoid that. We think the stronger message would be is even if years after the conviction, the person gets the deterrent effect of the suspension. The message then goes out, it doesn't matter how long it was delayed or what happened, a delay in paperwork will not get you out of this suspension.
But that ship has sailed.
In addition, what Justice Todd is saying, that we have the cases that we have. But beyond that, again, I mentioned that you're trying to protect the roadways. Apropos of deterrent effect, if our criminal justice system works correctly, there ought to be some deterrence in whatever the criminal sentence is that arises from this. And once you're beyond your first DUI, there's mandatory jail time or alternative to jail, but confinement time.
Well, yes, and that all happens on the criminal side.
Right.
And again, on the civil side, there's, it is simply a data processing in, sanction going out. It's all of those issues, and we don't allow at the appeals of driver license suspensions any collateral attack on the conviction. The question is not, should you have been convicted? What were the details? The question is simply, were you convicted? What were you convicted of? Did the PennDOT give you the correct suspension? That's the only issue.
In your argument, I deflected you a little bit. Your argument is that you have no control under the other 49 sovereign states, and therefore you should not have to deviate from your statutory obligation from the legislature because one of them made a mistake.
Well, that's right, Your Honor. It's the General Assembly that sets the policy. That's what we are implementing. But as far as the specifics of why not to extend Gingrich and Middaugh to Florida, there are, besides, as I said, the number of DUIs we get reported from out of state, not as many perhaps from Florida, but a lot from New Jersey, the coastal states from the summer, from vacation time. But there's also, I think as well, it's worth pointing out that the General Assembly sets the policy, and they often do that in conjunction with my client. My client reviews the legislation, looks at it, we get input from our systems people, our policy people, our administrative people, and my client is actually reviewed and audited on a regular basis by the Federal Motor Carrier Safety Administration, which covers CDL, or commercial driver license holders. And so we bring all that together to come up with a policy that works and achieves the agreed aim. We haven't had a case yet that involves a commercial driver, but that will come. And we will be back here again, probably arguing whether that's the case. We also have a case that's actually before the Commonwealth Court right now involving a revocation. And a revocation is different from a suspension. Suspension is merely the temporary taking of the driving privilege. A revocation is the full removal of the driving privilege. At the end of a revocation period, an individual must start with applying for a learner's permit. A revocation, the initial revocation, is for 5 years. The case that's before Commonwealth Court right now involves somebody who received a late notice of revocation that was 3 years old, the same period of time as the delay roughly here. Now, under the Middaugh bright line rule, that's not an extraordinarily extended period of time because it is less than the sanction plus 10 days. So we now have the situation where our bright line rule in Middaugh goes from 10 years and 9 days down to about 15 days because the shortest suspension PennDOT imposes is 5 days. That doesn't happen often, but most of them, there are suspensions that are 30 days long. So under Middaugh, 30 days plus 10 days, you've tripped the bright line rule, or under 5 years and 9 days, you haven't tripped the bright line rule. So the bright line rule for Middaugh is incredibly broad. And again,
Counsel, can I just ask for clarification? I didn't think that we blessed the bright line rule in Middaugh. I think what we said is that there were a number of factors to be considered.
Well, yes.
But there was no, you take the, 10 days minus 20 or whatever it was. I mean, I do not believe we affirmed that. Let me ask you a question. I mean, you keep talking about the policies set by the legislature and the policies that your department sets. We're talking about not policies, we're talking about like rules. We're talking about how much time needs to pass and things of that nature. I mean, and this is for what it's worth, because I believe Justice Todd is correct. This ship has sailed unless you can explain how a state can deny due process to a driver in the state because of an agreement that it has with another state. I mean, Middaugh was based on due process principles, but there's a way to fix this. I mean, if you talk to the legislature, we have a way to deal with this precise situation. Under our rules of disciplinary enforcement for lawyers, we put the onus on the attorney to report to the board that they have been convicted or they have violated the rules in another state, and the onus is on them to advise the court that that has happened. I mean, the only actor in this entire scheme that has total knowledge of what's going on with his or her record is the driver. I mean, if you talk to the legislature, which you seem to imply that you have those discussions, I mean, maybe you should try to work out a way that makes some obvious sense in the scheme of these things. That being said, though, how do we violate the due process rights of a driver just because you've agreed to do that with another state?
Well, this court's due process reason. Well, to go back first, I think you said this court hasn't made the Middaugh the rule. It's simply a factor.
The bright line rule, right?
But unfortunately, the way all the factors have been implemented by the lower courts now after Gingrich and Middaugh is that the factors have become simply rules. Now we have, as far as the extraordinarily extended period of time, went from over 10 years in Gingrich, and that is a very long time. And even under the rule, the McCoy rule, a driver after 10 years could reasonably believe that suspension isn't coming and move on with their life. We're now down to, I think middle was 2 years and 4 months. And that's really, I mean, in a different context, that's about how long it takes to prosecute a DUI, 2 years. And we're saying that that's too long. The remedial effect has gone after 2 years and 4 months. As far as the due process, certainly under the standard, well, either the due process, the less deferential due process, basically Middahl and Gingrich have added a condition to the rule, to the statute. The statute was PennDOT receives a notice of conviction, PennDOT imposes a suspension. Now it's become, unless there's a delay and certain factors. But that has been turned into the prejudice factor, which right in McCoy and in the context of a 10-year suspension, there has to be reasonable belief. It has now just become the prejudice is you were going to get a suspension. That's simply been watered down. The intervening factors, the intervening violations, very often, in this case, it was a speeding ticket. Oh, it's just a speeding
I think that the prejudice is that you're going to get a suspension, and it's going, and you pointed it out, it's going to adversely impact your life. You're no longer drinking to excess, and you're working steadily, and you're not going to be able to go to work. That's certainly prejudice. You had 2 kids, and you have to take them to school and get them home from school. Certainly prejudice. But if the person, and of course we don't see these cases, remains or is under the influence of alcohol habitually and not working and not productive, then they don't get the benefit of this rule. I mean, it's a carefully tailored rule, and Chief Justice Saylor wrote to it in Middahl too. I think eschewing the bright line rules and explaining the equities carefully.
But I think, Your Honor, the way you just characterized prejudice really goes to deterrent effect. In that, so you have a job that almost every job would involve driving, at least to get to the job. And the deterrent effect of the suspension is to impose that disruption, is to impose that hardship so that the person takes it seriously. And so, again, I would
I understand the argument.
Look at remediation and deterrent. And I've heard, it's been said that ship has sailed. That ship is basically something that was created by the appellate courts, and so they can change what they've done. But unless...
Nonetheless, it's a ship.
It is a very large and important ship, Your Honor.
But I think we understand the argument.
Well, it's a pretty leaky ship, isn't it?
Any
That's why
questions?
it's back here.
Well, that's, and so I think, Your Honor, if I could just conclude by saying
Sure.
what relief we want. Having looked at this, my client ideally would like, I think what Justice Mundy recommended, a return to McCoy. That's the simplest, that's the cleanest, that would take away these factors. If the ship has indeed sailed and we are left with a factors analysis, I would ask this court to strongly state that the Middahl rule, the rule that was put forward by Commonwealth Court, be struck down or be reversed or told not to use that simply because it is so broad and unworkable. If we are left then with Gingrich, and again, my client decided not to appeal Gingrich because it was 10 years. It was a very long period. What we would ask is that if this court decides that Gingrich is the correct approach, that it articulates more precisely what the factors should be. An extraordinarily extended period of time should be a long period of time, 10 years, not two years and 4 months or less, or the length of a sanction and 10 days. Just to digress for a second, that means that if somebody passes a school bus that's unloading children, the suspension there is 60 days, so 70 days, and they may be able to get out of that.
Right, but counsel, Justice Wecht and I dissented, urging a bright line rule, and I think that has been discussed and resolved in terms of what this court decided.
And ironically, it's at 244 Atlantic 3rd, 426, and you were counsel on the case.
Counsel, I thought you were here on an entirely different issue. I didn't think you were here to re-argue the strengths or weaknesses of Middow or anything else. I thought you were here to make an argument that the fact that the Commonwealth has an interstate compact with Florida made the difference in this case. And so far, I haven't heard why that would be.
That's right. I was responding to the questions I was receiving from the court, which were broader than that. But to summarize then, why...
Do that in a couple paragraphs, because your allotment of time is running short.
Okay.
Go ahead.
It's just...
Not that there's a bright line rule about how long you can speak.
But I mentioned already that Florida is out of the jurisdiction of the Pennsylvania judiciary. It makes sense to try and address the Pennsylvania problem the way the court has, perhaps. 2, the number of drivers we get reported from out of states. 3, I mentioned we will eventually have a commercial driver. The FMCSA audits Pennsylvania. If Pennsylvania is seen to be receiving reports of conviction but not imposing sanctions, that becomes an audit point, and the accumulation of audit points under FMCSA's rules threatens highway safety funds from the feds, and it affects our relations with the states, other states. We regularly meet with our counterparts in other states' DMVs. It will be harder to work with them if they perceive that we are not enforcing the convictions they report to us. And finally, which does go back to what we talked about earlier, if this court expands the Gingrich and Minaw to out-of-state reports, it basically compounds the problems that have been noted in the concurrences and dissents by the justices here of the problems of the Minaw-Gingrich approach to this issue. But I'd like to finish, if I could, with just one very brief thought. It's been said that in these delay cases, it makes no difference to the DUI driver whether the courts or PennDOT delayed the suspension. But if the DUI driver gets out of that suspension and then there is no remediation or deterrence, it won't make a difference to the person that that DUI driver subsequently crashes into either. Thank you very much.
Mr. Bach?
Good afternoon. My name is Francis P. Bach, and I am representing the appellee, who was the successful litigant at the lower court, Commonwealth Court, and utilizing the Middow II decision, the Supreme Court. All the court would have to do is take your first 3 pages as to the factual history in this case and substitute Middow with Naginey.
Well, that isn't quite correct, is it? Because in Middow, our decision was based upon a strict 10-day timing in the Pennsylvania statute, whereas in this case, the Florida Compact doesn't have any timing requirements.
Well, Your Honor, if I may, and it doesn't appear of record as to reporting requirements in the driver licensing compact, but the Commonwealth, in its brief to this court on page and I just picked this up today, said, kindly look at the driver's licensing compact, and perhaps I could ask my son if he can see that, what page in the brief. I think it's like page 12 or 13.
Well, what's the point you're trying to make?
The point is, they make a reference, PennDOT makes a reference in terms of explaining their concept, the driver licensing compact, as to Articles 1 through Article 9, Article 10. I did, in fact, have a copy of the driver's licensing compact, the version being the 1990, and the caption of that is the driver's licensing compact, the Administrative Procedures Manual, 1990. Now, you may ask, how did I obtain this? My background, I was in the same shoes that Attorney Bricknell was. I was PennDOT's legal counsel for almost 30 years, representing the Commonwealth in the courts of common pleas. 30 years at that level, I never had the opportunity to come before the Supreme Court. And I'm very privileged to be here because I'm at the twilight of my career. I'm 74 years old. My son, this is his client, and it was inopportune. He asked me for some advice as being the elder statesman at the Court of Common Pleas, and at that hearing, he happened to get sick. And Judge Shawley said, "Do you want this continued?" And I said, "No." Attorney Bricknell was there. He had his representative from the department. And I know from my experience, getting a representative and then having it continued is a pain. So I put the case on, all right? And at the time, Gingrich was new law. And counsel basically indicated this is the principles that have to be followed. Judge Shawley, in a well-reasoned, thorough analysis, went to each of the factors outlined in Gingrich. And he ruled, in essence, in our favor, that there was an extraordinary delay. For purposes of clarification, the delay that is sometimes referred to in the record at the Commonwealth Court is 37-month delay. In reality, it's a 39.5-month delay. What the 37-month delay was, the date from conviction to the date that was made through counsel's witness, Mr. Lapidata, it was 37 months. PennDOT received it, but took 2.5 months to process it. So after their receipt, it took them an additional 2.5 months to issue the suspension.
Mr. Bach, I don't know how much 37 to 39 months matters. It's,
No, I
we're going to try to wrap up what's been a long argument list. Their argument, respectfully, PennDOT's argument is they don't control Florida. Why should they be punished when Florida didn't get that in? And I think that's what you have to answer.
Well, Your Honor, you basically addressed that indirectly by indicating that the delay, we're not concerned about, is it chargeable to PennDOT? Is it chargeable to the clerk of courts? You're looking at what impact the delay had on the individual. All right? And that's why the 3 factors came in. It would be absurd to say just because it comes from an out-of-state jurisdiction, the delay doesn't count like it counts in Pennsylvania.
Justice Donna, who pointed that out, the issue's due process to your client.
Right.
So that doesn't impact the court insisted on this due process paradigm, so that's the leaky ship that sailed, I guess. But supposing that we feel constrained to follow this due process rubric in this statutory setting, don't you concede that that analysis itself is impacted by the fact that this is a Florida screw-up rather than a screw-up by a clerk here?
No, Your Honor, because the individual rights are at issue here. What impact under the Gingrich, Mid-Al 1, and your ruling, has on the, quote, judicial staleness, the public policy, and in this particular case, counsel and really never addressed the fact that in the driving record and at the Court of Common Pleas, I took time and effort to put Mr. Naginey through the cancellation of operating privileges that befell him after he was cited in the state of Florida. I indicated that Florida at that hearing was a unique state. It's what they call an administrative per se state, that once the operator, Mr. Naginey, had a DUI, he submitted to a blood alcohol test, and his reading came out .093. Under Florida statute, that mandated a suspension of operating privileges. And how do we know? Florida processed that suspension in a very timely manner. They notified the NDR, which is the National Driver Registry. Counsel had his witness testify as to what that National Driver Registry is. And it's a system that Pennsylvania's a member of, Florida's a member of, just like they're members of the Driver Licensing Compact. And what happened? They entered the data that Mr. Naginey, a Pennsylvania operator, has a suspension in Florida. What's under the next step that comes in the procedure is Mr. Naginey, as was explained by Mr. Lapida, was up for renewal of his driver's license. PennDOT's procedure is immediately when that happens to do an NDR search. And the moment they see problems in the state of Florida, he classified that as a hit, wherein his operating privileges were suspended. Now, under Section 1572, that suspension, in essence, is an indefinite suspension until such time as all the requirements of restoration in the state of Florida are met. They were met, and Mr. Naginey had suffered 23 months of cancellation based upon the incident in Florida.
Yeah, I read the various form letters. They were part of the record. My law clerk pulled them out. So, but if I understand what you're saying, is that you think we can look at circumstantial evidence, which we certainly can, and your client's already suffered a suspension arising from this.
He has already suffered,
but not under this statute. So PennDOT's here on this statute.
Sanction. I'm not saying suspend. You know, the proper terminology is a cancellation of operating privileges under Section 1572. Now, under the Driver's Licensing Compact, all right, which Pennsylvania is a member of, I think it's Article 5. Article 5 tells the home state that they are not allowed to issue a driver's license if an out-of-state jurisdiction has them suspended for reasons.
What's your point?
The point being is the Driver Licensing Compact worked. Florida, in a timely manner, notified the National Driver Registry search. However, 39 and a half months, there's a delay in which the conviction is processed.
Right.
And that 39 and a half month delay is basically the grounds on which Judge Shawley, he ruled. He was looking 37, 39, and it really isn't based upon the court's disposition in Mid-Al 2 that 28 months was unreasonable.
But he couldn't renew, right? It's he could not renew for those 2 years, right?
Correct.
Isn't that what it was?
There's no operating privilege.
So is there a legal standard that you want us to articulate here, or will this court now just be in the business of continuing to arbitrate these disputes and sort of seat of the pants assess whether something's fair or not?
Well, Your Honor, you know, PennDOT under the statute, Section 1531, is administratively given the authority to administer and integrated systems of suspensions, revocations, cancellations. Inherent in its administrative duties, in essence, is, you know, an ability that they have to monitor what's happening. Now, delay cases, I call it the old school that PennDOT has basically been promoting, that it has to be delay chargeable to PennDOT coupled with prejudice. That's the old school theory, basically as being disregarded under the line of cases that my son put in his brief. He's basically arguing the point that Gingrich, Mid-Al 1, and Mid-Al 2 is the authority for this court to, in essence, at the very minimum, affirm the Commonwealth Court.
But counsel, what you're saying, if I understand correctly, is that this is a case of PennDOT delay, because when the information was put into the National Registry, they were effectively on notice of the violation and suspension in Florida.
Well, they would have been on notice because they are also a member of the National Driver Registry. However, I know the internal operating procedures that they're not going to be checking daily the millions of operators. It's only when they're up for renewal.
And that's what happened here. And that's what happened here.
That's what happened. In this particular case, he was up for renewal. They said, you're not going to get renewed because Florida has a sanction against you. You can't get renewed until you take care of the Florida sanctions.
Mr. Bach, Justice Todd has a question for you. I'm sorry.
Mr. Bach, would you comment on Mr. Bricknell's observation that this situation, if resolved in your favor again, will impact negatively the relationship that PennDOT has with other states?
Yes, Your Honor, because as I was getting back to when I got off track, on the driver's licensing manual, what was not mentioned, they have all the articles, that are basically the same as seen in Section 1581, Article 1. It's the same language, but it's a administrative procedures manual, and it's for guideline for motor vehicle administrators. Now, PennDOT makes the assumption that there is no time constraints in which the jurisdiction must notify PennDOT. Surprisingly, under the procedures part of this manual, it says, reports of conviction, Section 2.41. Each jurisdiction shall report each conviction of a person from another jurisdiction occurring within its boundaries to the home jurisdiction of the licensee. 2.42, timeliness. Each jurisdiction shall report each conviction in the home jurisdiction of the licensee within 15 days after receiving a report of the conviction from a court. So there is within the driver licensing compact, all right, administrative procedures that the states should be complying with.
But how does that answer my question about the concern that Mr. Bricknell expressed that the consequence of this could impact Pennsylvania, PennDOT's relationship with other states?
Let me address that very briefly. The vehicle code, all right, creates that every member of the compact shall meet annually. In other words, a representative, either the Secretary of Transportation, they go to, at the very minimum, an annual meeting. And what happens, I would assume if they're being proactive and trying to resolve issues as to late certifications from clerk of courts, late certifications from a home jurisdiction, they have the ability to communicate. And that's the key, communication. My years with PennDOT, when issues came up, the next step was either a legislative fix. We didn't like the disposition. We don't like how it's affecting our production of cases, how we're going to defend these cases. So they seek a statutory amendment, et cetera. The same way with the driver licensing compact. These member states have the ability to modify upon agreement. And so in terms of your answer, there is a methodology. They're required to meet, and I'm assuming it's not just a social meeting, that they're basically in consultation with the AAMVA, the people that basically created the ACD codes that was part of this record, as to, is this a DUI if it comes in as an A20? So there's means out there where...
I think we understand. Is there anything you'd like to say in summation?
I'm sorry?
Anything you'd like to say in summation? We're a little far afield.
Oh, okay.
What you're doing is very, very interesting, but is not especially germane.
I was taking leeway because counsel basically went into all the policy decisions, et cetera.
I think you've argued the case. I don't think we have any questions. Why don't you sum up?
Your Honor, like I said, this being my first visit, it just reminded me of certain things that, you pick up over years of practicing.
It reminded you how much you miss it, right?
Well, I'm in semi-retirement mode. And as I told various judges I appeared in, are you still doing? I said, I get interested in cases that are not the standard run-of-the-mill. You know, and this is basically a unique case.
Mr. Bach, finish this
I
argument
was just
for me.
saying,
I threw him off.
It's not, it's all right.
one thing that came to my mind is, before your honors, the law does not change the facts, but the facts can change the law. And that's basically the genesis of what happened here with Gingrich. You know, you had that 10-year delay. The lower court said, okay, we're going to follow the old school that delay must be chargeable to PennDOT. And that's when this court got into the very thorough and well-reasoned analysis as to due process, et cetera. And I would submit that, you know, all the courts involved in this case were correct.
Thank you, sir. We appreciate it. Court will stand in recess.
Counsel, your son is very lucky to have such a good mentor as you.
Thank you.
Thank you all.